Yes, yes.
First of all, my lord, before I start, we'd like to complain, my lord, for very convenience, my lord, because this is not the right time for a lawyer to take your lordship. And
And I'd also like to tell you that I am not well today. Suddenly my pressure shot up today. I'm also not very well. But you can continue.
so, my lord, so far my case is concerned with very limited high pay. I was arrested on 16/12/2024. Today, my lord, I am behind the bar for more than six months, my lord, in connection with a case which is of, my lord, serious nature, my lord, relating to NDPS, my lord. So section was attributed, my lord, 22(3), 21(b) was imposed. So admittedly, my lord, 180 days should be the mandatory. Now, so far, my lord, my grievance is concerned, my lord. When I was arrested, my lord, on 16, I was given
16, 16,
16/12. My lord, lordship mechanism
16, 12.
2024.
Okay.
4 days remand, police remand has been given allowed consecutively on 2 days for 16 and 20. Now, on completion of police remand, my lord, on 24, I have been, my lord, sent the judicial custody. That's one is. Now, in the meantime, my lord, we file a petition for the concerned court saying that raising a juvenile of my age, my lord, this is the facts behind the reason. Although I am arrested in a heinous offense, so since I am a juvenile, you kindly refer me to the juvenile justice court having competence in terms of so and so.
All right.
Now, London Court below has passed an order referring the matter to the DGP. Now, after that report has been transferred to the DGP, the London GGP on 7 February, my lord, passed an order for conducting an ossification test.
Okay.
While filing the application, I have enclosed all the documents so as to substantiate my claim that I am a juvenile.
Okay.
But Learned Court below, straightforward, my lord, conducted an ossification test, and the ossification report has been received immediately thereafter, few days on. I have annexed 10 and 10A. Thereafter, OC of OCA BSS submitted, my lord, the report, and that report closing the medical ossification test, which shows that the accused was, my lord, beyond 18 years. That was the findings of the medical court, my lord. It was conducted in Naga Hospital, Kohima, my lord. No, maybe
It's okay. It's okay. Okay.
now, my grievance is Toshi Mechanic have a juvenile justice act. 2000
Yes, it's okay. I know. You are referring to the documents.
section 94.
School certificate.
Yes.
Okay.
It's very clearly provided. Toshi Mechanic have for a moment clear me, my lord. I will not take much time. Section 94 says, clause 1, there is, can you see, refer that section, my lord.
All right.
Section 94, clause 2. 94, clause 2 says, my lord, subject to 1 and 2. There is clause, subclause 1 and 2.
Just a moment.
Page 99, my lord. Annexure 14, my lord. Saying that a report has been called for, my lord. On 8, that is fixed on 8. It was passed on 24, my lord. 24/6, my lord.
This case is under trial or under investigation?
No, under investigation, my lord. Investigation.
So you have stated that you were arrested on 16/12/2022?
Yes.
Hmm.
My lord, I'm projecting, my lord, why habeas corpus has been filed, my lord. Because of the reason that, my lord, Act does not say so that a juvenile, once a juvenile is arrested, you should be put behind the police station or you should be put behind the bar, my lord. I am a juvenile till my juvenility is ascertained, my lord. I should be kept under observation home, my lord.
But your juvenility has been ascertained, no?
My juvenility has been, my lord. How it is ascertained, my lord? That is the question I wrote, my lord. Section, that's why I'm lordship at first instance I was taking you to lordship section 94.
So what is this that you were arrested on 16/12/2022?
Hello?
You have stated that you were arrested on 16/12/2022.
That arrest, my lord, is an illegal detention, my lord. I should be kept under the custody in an observation home, not in jail, my lord, like ordinary, my lord. Section 10 is very clear, lordship. Section 9(1) is very clear. An observation which must be posted, my lord. That will amount to, my lord, illegal detention, my lord. What is the object of the act, my lord? For the interest of the juvenile in conflict with law, my lord. What is the object of making them enacting the 2015 amendment, my lord? Enactment, my lord.
All right.
And lordship is very clear, my lord. Once, my lord, I am produced in a position to establish my claim in terms of section 94, providing necessary documents one into birth certificate or the educational certificate, school certificate. There is not required at all to conduct ossification.
Okay, I got your point here.
She is quite aware. I need not elaborate, but certainly Supreme Court also held, my lord. This is still the law, my lord. I may only one judgment I may place, my lord.
You have placed some document, isn't it? Regarding the birth certificate and all.
Yes.
So was there any query from the court that whether these are the
Not at
documents
all, my
are
lord.
genuine or not? Whether
Not
these
at all,
any-
my lord. That is what, my lord. As per the act, the learned JJP has to conduct an inquiry. What is the inquiry? Neither the investigation, my lord, officer, my lord.
School certificates.
School certificate, my lord. Birth certificate is also there, my lord.
All right. Your
So-
judgment?
Only one judgment that may suffice, my lord. I have other judgment also, but I'm not troubling your lordship today. Page paragraph, my lord. Kindly see paragraph 27. Paragraph, no, my lord, paragraph 27.3. That is the medical documents in that case also, my lord. Medical documents, ossification test was conducted in that case. Now, paragraph 27.4 is that JJP has accepted a medical report. In the lordship may kindly note down the paragraph. Then paragraph 28, lordship will see the findings by this, my lord, now lordship before that, paragraph 27 is the certificate, my lord, 27 in the in that case. And then paragraph 28, my lord, section 94 was, Supreme Court has clarified section 94, the position. Now then, my lord, section 30 in the order, my lord, lordship, Supreme Court has already accepted that certificate as a minor, my lord. So that ossification report, my lord, was not struck down by the Supreme
That
Court.
entire paragraph 27.
Hello?
Entire paragraph 27. 27(1), 27(2), 27.
My lord, not one, my lord. Lordship may kindly paragraph 28.7 is the school certificate. Then paragraph 28 is the birth certificate. And paragraph 27 is the medical report regarding ossification conduct process. And paragraph 27.4 is the acceptance by the juvenile regarding the medical ossification report.
You can obtain instructions if the this petition extension prayer has been disposed of.
Oh, my lord, so tomorrow is the fixed date, my lord.
Okay.
Kindly, I have, my lord,
Which page?
my lord, last annexure, my lord, second last, annexure 13, my lord. He speaks tomorrow, my lord. Lordship may have page, my lord, 98, my lord. The relevant part, my lord. No, no. Page, my lord, 9.
98. Nice, then go on.
1. It is speak.
1/7/2025.
NDPS lordship is quite very nowadays, my lord. Accused must be informed, my lord.
They have
Oh, my
also
lord.
filed a bail petition also. As per the last page,
Last
page
page, that is-
99.
That is what, my lord. I filed a CTD repair that has been denied.
Which is fixed on the 8th of July.
That can be, my lord. Lordship is quite aware.
Page 99. 87. You take up the instructions that bill petition, they have filed a bill petition which is pending, I think.
Yes.
That has been denied, my lord. And fixed for further hearing along with my lord
CD.
CD as well as status report as well. No, that should not be exercised, my lord. That cannot be, my lord. The moment I exercise my right, my lord, once my lord charge sheet has not been filed anything that on file, my lord.
So you are asking for interim.
My lord, at least interim, my lord, I should be, my lord, on at interim. my
Okay,
lord.
we will decide. You can obtain you can go through it and come back after some time.
Otherwise, my lord, immediately as per what my lord, whatever documents I have submitted, it's a file. It may lordship will have may finally dispose of, but I'm not insisting, my lord. At least less than 3 opportunity, my lord, because every documents I have annexed. Annex 3 is the 3 fully are the documents substituting my juvenility, my lord. So in terms of section 94, my lord.
All right, all right.
Item number. Okay.
Yes.
Yes, my lord. Yes, I can loan. Not with that. Loan. Care of forensic. Petitioner has regularly paid the installment. But from the month of year of 2019, during the COVID period, there is some irregularity to paying the toll because his business has always been collapsed. And my lord, I am they file a uh, case before the debt capital recovery being OA number 480-2024. That case is pending. I also appear, and the case is finally hit for hearing on 28/8/2025. In the meantime, my lord, what happened? After filing that case, they put a notice. Whom notice method place 33 months.
Yes.
Place 33.
Okay.
Then, my lord, now they ask to get the land, they will take over by something. But the case is already pending. Also pending the complaint of my- Yeah. Bill is bearing number on 30/11/2024. The date to go to terminal. Why? against the petition for revoke of the loan amount. After receiving notice, the state says that now the state is not to pay it, 25. Now, my lord, I am ready to pay the entire amount. I am ready to, at least that case is to be decided. And in the meantime, can get issued a document within 6 months. If they apply, I will pay the amount. But now, suddenly during the pendency of this case, they again issued a notice under section 32 of the Secretary Act. Two parallel proceeding, my lord. Under the I will pay the entire amount. Then this notice will be stayed, and I will debt filing to the debt tribunal is to be decided, my lord. It is decided on 28 final hearing. Whatever the outcome, we will follow it. And there is also provision to file a bill before the appellate authority. Any party can go and file a bill. So, my lord, the matter is fixed. The petition, in the meantime, that notice may be. So, I will be. I am ready to pay the entire.
So
From
earlier,
2016, I am regularly paying it. 2016. And from during the COVID period, I could not pay.
there has been one case according to paragraph 10.
Paragraph 10.
When this case was pending, notice has been issued.
Notice. Under section 13, 2, notice has been issued.
Okay.
They cannot do it. At least they wait for the decision of the tribunal. That decision has not been come, whether they are entitled to get it or not entitled to get it. They should follow it. I am also bound to follow the decision of the judge.
No, government will কৈছিলে যে হিচাপে কৈছিলে যে মই সেইকাৰণে গভৰ্ণমেণ্ট ধৰিছো গভৰ্ণমেণ্ট খিনি বুলি আছে
Section 13, 2.
ষ্টেট বেংকৰ আইডি যে দিবলৈহে কৈছিলে মই আছে বাইদেউ কয় হ'ব নেকি চাৰ্টিফিকেট তাৰ
Let's go with the now. And I am also ready to pay the entire amount. I am regularly paying, but from the year of 2019 during the pandemic. That is why some.
Where are your grounds? Please highlight the grounds. One is page 10, paragraph 10, and the other grounds that you are paying regularly.
This they cannot so that notice. They should wait the decision of the debt. Whether they file a case for recovery of the loan amount. How they again directly issued notice without waiting for decision of the debt to go to tribunal. And even my lord, if judgment is come against me, then I have a right to file a bill before appellate authority. That's right.
You're employee under?
I am not an.
You're not an employee.
I am taken.
You're a private person.
Business has already collapsed during a pandemic. From 2006, I am regularly paying.
Where do you have documents annex that you have been paying regularly and in pandemic you could not pay?
Paragraph 6.
Any receipt statement, bank statement, receipt?
Yeah, but I
Any bank statement? Receipt?
yeah,
You have taken loan from which bank? SBI. You'll get a online receipt also if you want.
they also annex the case in the department. Appeal of the there has some bank statement.
In the appeal,
The
in the OA. You have given the arrangement letter, but notice ought to have been annexed. And the statement ought to have been annexed.
very last period there. The last day.
Can you bring the statement, short date, within a short date?
No, after vacation, it may be hit. They make them. I will place all the. They will in the model. One is there, they also have a case. Last page, last page, 1 lakh I paid. Yeah, it is their document. This is the way, my lord, way. I apply the petition. Way case number. Now, along with where they enclose. Then what was it enclose the bank statement? Lots of cases, last page, 1 lakh I paid. On full. I didn't pay. If, there is something called, it is correct. Of 2019, there is a default. I could not pay. And it.
Order of the debt recovery. It is not, order is not here saying one and the
I make
case
it.
is fixed on 2018, but
I
order is
made
not
it.
here before us.
I made it.
Can we say that any cases
I
pending
made- I-
before the debt recovery? It's not.
Calculate. I made it. I made a statement. If this is false, then the consequence will be followed. Correct, my lord. At least the order of the tribunal. Every tribunal. Because I. That this one on two. This one. This one. After 2 days, they will take position. That is why. No, they inform order, there is the last page. Yes, 34. He also, they want a magistrate to the law and order. That's the 1034. Last, they tentative, they went to 7. Down below. Just had to done. They take over position by
Scope is very limited, na? That's what they take the petition.
But-
Scope is very limited.
very limited
So you are
against,
not
against the
anything
judgment.
Here.
Against the judgment, I cannot come here, madam.
Not
Against the judgment, cannot come here. But when illegality has been done, I have the right to appeal decision of recruitment. Here, one time they filed a case, and again they issue notice directly, my lord,
You're saying that
bypassing
one is
bypassing the case. my lord.
pending before tribunal, but we have not annexed anything. So how can we believe that case is
I give the memo, copy of the memo of that case. my lord. The second is the decision they filed. Yes, my last tentative here, tentative one. They had acted illegally. It is correct. No? Last page. Page 54. Last handwriting portion there. Last handwriting portion. Tentative. Yes, tentative. Tentative. They has committed wrong, my lord. They has committed illegality. Where will go, my lord? They will come here. But it is our fault that I could not finish the uh, order passed by the tribunal. It is in the matter of the 885. I make a statement on note. Because they will come. They will take over. It is fixed on pain or reopening there. Just one during that temporary.
very good?
As it is urgent matter, we'll issue notice on 10th. We have pondered over it, we mulled over it, and we think that it will be best to, because she has also given some suggestions, and I find it true, because you see, the last date was the 27 2024. Since then, no action has been taken, and now with handwritten, they have fixed tentative too. So on 10th, meanwhile we will issue notice. Our learned counsel, Mr. J. Ahmed, order.
The notice, my lord, they seven days time. It was not tentative also. In notice also, 7 days time.
Hmm.
Paragraph 3, my lord. Page 33, my lord. Paragraph 3, my lord. However, you make clear of the use including address of the school within
Just
Seven.
tender one EMI. Meanwhile, just tender one EMI.
illness permit.
No. Why should I permit?
And they're not
It's
taking.
between you and the bank.
I go there. They're not taking. Ready to pay. Not one installment. More than 1.5 I can take. But they're not taking.
Learned counsel.
That I may have to pay 1 lakh. I don't know why.
J. Ahmed, learned counsel for the petitioner, Lokmal Ali, who has filed this application. Under Article 226 of the Constitution of India. challenging the notice to vacate the land in default of payment of home loan AC number 35978543491. Petitioner to take steps to issue notice to the respondents.
Today, sell right. Today,
Yes, respondents as per usual process.
Usual.
Usual process returnable on 10th 10/7/2025. Meanwhile, meanwhile to nothing. The petitioner has also submitted that he may file. What do you want to the last copy of the
last copy of order.
or the copy of the last order passed by the debt recovery tribunal, as well as bank statements to countenance that he has been paying the EMIs regularly till the COVID period. List on 10/7/2025.
Item 3.
Inspector ahorita vamos a poner esta IRB. So their cases there, they are senior, they were referred to prior to the 17th. They become eligible in the 2020. But till now they have not been promoted. Then according to prior to the 2020, then by issuing a WT message. But their documents did not end it their own. Most of them, they filed this. After filing this, the service rule was amended. After amendment of the service rule, a new WT was whereby the name was there. And some persons were much junior to the their name were reflected in the they were and one stability that new document that was not there. This like it. New Here's one of IRBS. Next, serial number 11. The petition number 1. Is date of economy in the present post is
Milo Raja.
Milo Raja.
Okay.
25/7/2012. And the petition number 5. Number 12. And he is the serial number 15. 4 is the serial number 17. And this number now the new WT method. That is 164.
Their names have been included in the consideration for promotion.
Yes.
Not yet promoted.
No. Consideration was
Okay.
for here the first person. So, look at this one.
Okay. Yes.
Civil police.
Mm.
The number 1 is Pok Lanka.
Mm.
This Pok Lanka is number 1.
164.
Yes,
Number 1.
number 1.
Okay. Serial number 1. Yes, yes, yes.
He is the senior most, his name is the top of the list.
Hmm.
Applicant time to the state with Pandey. Is what 28.
He has joined later.
Yes.
128 years.
128. Number 6. His date of appointment in the present post 14
Okay, okay.
the date of appointment present post
Okay,
is-
okay, I got it. 2012.
Yeah.
Hmm.
Now note it, the earlier document itself. Number 01.
101, yes.
Fine. Number 14.
Okay.
There.
Their names are behind them, trailing. So your names are trailing. That is why you are aggrieved.
Yes. Because I ought to be promoted, the service should say that after completion of 5 years, the petitioner become eligible for promotion on the merit seniority company. So I became eligible in the year 2017. Till 2023, there were 19 posts. And as per the GOPT guideline, the post fell vacant at that 11 point of time, and the time of listing will be that may be followed as per that. So accordingly, my case is that my case will be followed, and I may be promoted that post as per the relevant service rule, that is 2006 amendment. What will find numbers of 21. I have again reply. Whereby it was
Page 2. Page number
221.
221.
Number 2. Number of proposal vacant post PS, PSP or
Please switch on the speaker. Can't hear you properly.
So, at serial number 02, the number of promotional vacant posts for APPS EG from 1st March 2022 to December 6, 2023. After December 23, the 2023 rules came into force. So before that, these 19 posts were vacant, and the petitioner became eligible in the year 2017 itself. So this writ petition was filed to consider their case for promotion. For the subsequent development, I filed this petition, but that stay was not considered. You also will find a order. Page 241 on the learned single bench.
Hmm.
Having considered the applicant's petition are impleaded in the private respondent in the concerned connected writ petition, however, they have not been added as party respondent in the interrogatory application. The applicant petitioner granted time to file appropriate application for impleadment of the private respondent. Now, Lordship, the petition, the private respondent are already in the writ petition. This, before they were impleaded, this petition was filed. So on that day, they were directed to be impleaded by filing a petition. If I file this petition and thereafter court allows that, and after that, for consideration of this petition, it may take long time, because your lordship will find page number 242 WT message, whereby all the process was directed to be completed within
Page
30th.
42,
242.
242.
That is another WT message.
Hmm.
So the process is directed to be completed by 30th of June.
By
By 30th of June. So there is some urgency.
this 30th of
Yes, Lordship. The process means that the by which WT message the vigilance clearance or other things.
Now you have added them as parties.
Lordship,
in this
today they are
appeal?
going to file petition before the before the Itanagar High Court. So that may come within 3-4 days, Lordship. But if it is allowed from the next week, vacation will be there. So in the meantime, the process may be completed. So I need a stay of that process till disposal of this requisition. So Lordship may make some endeavors directing them to complete the disposal requisition shortly.
May I please, Lordship? Lordship, may come to case number 241, Lordship.
241. Yes, I have seen it.
Lordship, there they have made the private party that as respondent in the writ petition.
But not in the.
Honorable Court has very correctly said that in the interlocutory application that they have to be impleaded because they will be affected if any stay is granted. And this next 242 page annexure 5, Lordship, that WT message is of 26/2025.
Hmm.
Is of 26 of 2025, and this order is of 25th 241 page 241 and 20.
Wait,
My lord,
we
the
did not have that
petitions they
message.
were sleeping over the order there,
No, we did not have that order earlier, Lord. Recently we have.
and no statement is made in the writ appeal that they were not aware of this order earlier.
No, Lord. May I
You have
continue?
not made the statement in the writ appeal.
No, Lordship.
Lordship, it was an order of 2000. The court may grant the stay even without hearing the parties. Yes. No, Lord. No, Lordship. That was 241, Lordship. Then, no, final order has not been passed. I am coming against them. I am not, I am coming against this 241 order, Lordship, for not granting stay, Lordship, because even without hearing the private respondents, court can grant stay in an urgent matter, Lordship. And this is an urgent matter, Lordship. No, this writ petition, Lordship. In the writ petition, I filed the application for stay. I am coming against that order passed in the stay application.
If stay is granted, Lordship, then the private respondents will be affected.
No, Lordship,
Those who are
in-
late parties
in,
in the
in every case, interim orders are passed without hearing the private parties. If court is satisfied that the stay will be granted, then court passes the order.
then the WT
And
message
here,
of-
Lordship, the petitioners are senior, but they were denied the benefit, Lordship.
we could have approached the single bench today by filing the
No, Lordship.
this one, Lordship, and also could have filed an interlocutory application against this Lordship, the order WT message dated 26.
Yes, Lordship, not exactly earlier. This state petition. Yes. No, I'm not stepping like that. So I filed writ petition in the in April. After filing this writ petition, the WT message, the rule was amended and this WT message was issued. So in that writ petition, yes, Lordship, this is the same writ petition, Lordship. Yes, Lord. No, not a decided one. Yes, Lord. So my guess is that till the disposal of this writ petition, some time may be fixed to disposal of this writ petition. Till then, Lordship, the stay may be granted, Lordship.
Lordship,
And
the-
in that even I shall be protected. Otherwise, I shall be aggrieved because I am a senior person. My seniority was not considered. And since the service rule says that I am eligible for promotion, that WT message. No. I yes. Yes. Yes, of course.
Lordship, the thing is that Lordship, the order dated 25/6/25 passed by the learner single day. The matter is supposed to be listed the next week on 25th, Lordship. It was passed. Next week means this week. Court is there till 4th of June, Lordship. So within these days, they can approach, they could have challenged this WT message there itself, Lordship, and they could have filed a petition for impleadment of the private respondents in the interlocutory appeal.
It is done in the IL, Lordship. That was not allowed.
They haven't made a party where they are seeking as a party, private respondents. They have impeded them. Lordship, that can be done. Lordship, the matter may be taken before this court. Before the single bench there. Lordship, that can be done. Lordship. Lordship. Lordship, Lord. Lordship, Lordship, in the IL, Lordship.
Please correct me, huh?
Yes.
If I get something wrong, please correct me. Our learned counsel, Mr. R. Sharma,
Yes, Lordship.
for the appellants. Appellants के पास होना सही 1, 2, 3, 4,
I
5 who have filed this application. Who have filed this appeal, who have filed this appeal against the order dated 25/6/2025, passed by the learned single judge in IA civil number 161 of 2025, connected with writ petition civil number 172 of 2025, as their prayer for stay of holding DPC was not considered by the learned single judge. Heard Mr.
Lordship,
A. Chandran,
Lordship.
learned government advocate,
Their,
Lordship,
their prayer for
Senior government.
stay in
Lordship,
holding
may come
DPC.
to page number 185.
okay. Senior government advocate, Arunachal Pradesh, page number 185.
Lordship, the prayer portion. They have come here, approached the learned single judge to stay the impugn WT message dated 5/6/25.
5/6/25.
Yes. $185.
Complete read that you have. WT message. Okay. Dated, yes, 5/6/25.
That may be rich.
This, but they have, they are pressing for the order
Lordship,
They have come against the order dated 25/6
Lordship.
and this WT message,
This was to be
they have
stayed.
prayer in the WPC.
No, not in the WPC, in the.
In the stay petition, Lordship. This
Stay
prayer is in the stay petition.
IA, Lordship,
Okay, in the IA.
161.
More.
Prayer of holding of DPC is in the writ petition. Prayer of holding the DPC is in the writ petition, Lordship. And
No, that is a writ petition.
yes,
Lordship.
I have mentioned it is
Lordship.
as the writ petition. The petitioner, the appellants have also, you correct me again if I'm wrong. The appellants have also, the appellants had as writ petitioners, the appellants had as writ petitioners in the IA had prayed for stay of the WT message
Lordship.
dated 5/6/2025 issued by the IGP within bracket ADMN bracket closed Itanagar, stopping the process of holding DP as an interim measure till disposal of the connected writ petition. Number, what was the writ petition number?
171 of 2025.
172, Lordship.
122, Lordship.
2025. The interlocutory application was was to be considered or disposed of. Having considered the applications have been, however, they have not been narrated, that being granted time to, in the interlocutory application, the London single judge by order dated 25/6/2025 directed the applicants, appellants to implead they will be
Affected parties, Lordship.
to the affected parties. Within bracket promotees.
No, they are not promoted. They are also to be promoted by holding DP.
Okay. Affected parties as respondents, as private respondents. But the appellants are before this court as owing to the shortage of time. As the matter is fixed just before the vacation.
Yes.
On when is
That is not fixed after 1
It
week.
is fixed, Lordship.
not yet is fixed.
It is a list after a week. Means before 40,
As the matter is proposed to be listed after a week,
Lordship.
just before the vacation. And meanwhile, the entire petition would be infructuous if the process is
Not state.
not state. Process of holding the DPC is not state. Process of holding the DPC is state. They are just about to form the committee.
Lordship.
They have not already started the process of promotion. No.
Lordship,
Proposal
164.
It does not appear to be that urgent, but I
This is regarding
allow it
promotion.
to approach her. Sorry.
This is regarding promotion from the rank of inspector to APPS entry grade. This connection is requested to furnish NOC regarding law enforcement, etc. etc.
Lordship, everything is before the learned single.
Yes.
Lordship.
We have considered the submissions at the bar with circumspection. It appears that the appellants may be allowed to implead the what were they
Affected parties.
affected parties as respondents in the interlocutory application immediately on when
Third, Lordship.
Huh?
Third.
on 3rd. Till then, no, the process is stayed. The process of holding DPC is stayed. Till then,
The process is kept in abeyance, Lordship.
kept in abeyance, okay. Process is kept in abeyance. There'll be a little bit of tweaking of the order
Lordship.
with proper
Lordship,
words.
Instead
proper
of,
inserted words.
instead of filing this writ appeal, Lordship, the petitioners could have filed a petition to implement.
Lordship,
It is submitted by the learned court liquidiva, by the learned senior government advocate, that the petitioners could have easily approached the learned single bench with their grievance
Lordship,
instead of filing this writ appeal.
Lordship.
In terms of the above observation, this writ appeal stands disposed of.
Lordship, only one thing, not till the date of filing, till the date of consideration of the impleadment. Because after impleadment, I have to file the, I have
No,
to
that
file.
will be considered by the, I'll just send it.
That has been.
That will be considered, they will definitely consider after hearing you. Because now there will be another
True, Lordship, but what I am saying that
there will have to
on
be an
the-
elaborate
on the-
hearing on that.
possibly the implementation shall be filed today itself.
It
I
will
will say
come
that.
before.
So after filing, it shall come before the court on third or fourth
So
for
if
consideration.
I
Court will
consider
allow,
there has to be an elaborate hearing. So
court will allow, and
we
then
better save time and allow the court, he will take up the matter, and if you are again, there will be, the process will already be stayed as it is. Deferred as it is.
Lordship, that
Kept
may
in
be given
abeyance.
third of.
Yes, 3rd of
July.
July.
Till 3rd of.
Because without hearing elaborately, then I cannot consider all those things, because why they are not taken up for promotion,
no,
why they were
I'm not on.
superseded.
I'm not on that. My practical problem is that on if I file the application for impleadment, that will be allowed on third. Then I shall file application, file amended petition. This I petition by inserting their name. Then only the petition shall be considered. So my prayer is that till the date of consideration of my IA, stay may be granted.
Yes, can be. Kept in abeyance till.
Lordship, by taking this order,
till
and
the-
a mention may be made before the honorable single judge.
No, Lordship. It will be
That
clear,
can,
Lordship.
Lordship, single judge will consider certainly, Lord.
Till the date of.
Before single.
Yes, sir.
Third,
Lordship.
before third also you can file an AI.
It is filed, Lordship. Perhaps it will be filed today itself.
Item number 1.
Much obliged.
Only till this petition is considered, Lordship. That may be made clear, Lordship. Till the application for is considered after impleadment.
Lordship has given a date, 3rd of July. That is it.
It's okay. You don't worry. Don't worry. Item 1.
Much obliged.
1. Oh, 1. Wow. That's all. May I, Your Lordship? With regard to the mandatory period, of course, like I mentioned, 180 days, so which is already over. And charge sheet has not yet been filed. But with regard to the maintainability of this particular habeas corpus petition, Lordship may keep this open because I'm not prepared to pass on today. I have my objection to that. And with regard to the petitioner saying about this thing, he being a minor, juvenile, if your Lordship may turn to page number 81.
Oh, delivery order.
Item 1, this is rejected. Bail application rejected. I'd like to inform that mention won't be taken now. I'm really sorry, because mention will be through proper procedure, that is through email. And then we won't be able to accommodate also more of it. Won't be taken up. Through email.
Lord, purpose of vacation bench, you have seen for the last 45 years is that vacation bench takes up unlisted also.
But now the procedure has been changed. It will be through the email. Mention won't be taken up. I'm really sorry. It will have to be through the email. I'm so sorry, because you see this on 10th there will be 3 benches. But you will have to mention before 2 days, prior to 2 days, and that too through email, not in the bench.
My lord, the problem is,
Vacation benches are set up for taking very urgent matter.
Yes.
This my matter, I don't know my.
Mention
That-
has to be through this emails.
no, my lord, but that was up to time, my lord. That was up to 12 12
We have a
noon, my lord.
petition bench on 10th.
But 12 no, 12 noon, my lord, on 28/6/2025, my lord.
It
Up
will
to
be on
12.
12 noon only. It will be
Only
12
only
noon.
12 noon, but our case, my lord, due to some difficulties, my lord, we filed it after 12. So
As
it
it
could
is,
not
AB
mention, my
would
lord.
be taken up. AB will never be taken up, won't be taken up.
But
AB
in the meantime, my lord, some
AB
development
is
will
not so
take place.
urgent matter. AB won't be taken up.
My lord, your lordship, kindly appreciate, my lord. I have a case.
Three benches. We have 3 benches. I'm really sorry.
My lord, just a minute.
We have 3 benches on 10.
My lord, earlier was the day, we have seen, we seniors, case filed today at 3 was listed tomorrow compulsorily without any mention anything. Now is a digitalized computer,
But the proper procedure has been provided.
and my lord,
That is
every judge has
been
2-3 stenos, then also everything is
But
going
at least,
slow.
my lord, my matter becomes infrastructure, it is not taken up by.
Today, my lord, yes. My case also will be in fact.
As it is, I am not well. I think I'll have to take leave only. If I take up all the mentions, I'll have to take leave only. I am not well. And even the other bench is also not well. I'm really sorry. I'm not well since morning. I've been saying, but
Why not?
as I have
Because of such-
agreed to be in the vacation court, so here I am.
True, my lord, that we, my lord,
Today
see,
I'll
but
have to take up leave. I am suffering from high pressure. Suddenly it shot up yesterday. Suddenly, and then this was not expected actually. I was having low pressure all these years. Suddenly it shot up yesterday, and then my
lordship, then
my colleague is also not well.
your lordship should go get admitted immediately in that.
No, this is true.
Because this low pressure going up is not good.
Yes, but this is true.
In this case, Lordship, tomorrow is Lordship, in this case, Lordship, the warrant of attachment has already been issued, Lordship. Tomorrow is the date for execution, Lordship. According on 27, we have mentioned
I
before
cannot
the
take
court,
the warrant.
but the honorable court has allowed.
See, you were
2 days.
given 2 days time.
No,
You were
Lordship,
given.
today is allowed, but due to, unfortunately, due to Lordship, the file has been sent.
I love that.
Another Lordship, no, it was not listed, Lordship. So already,
Sir,
on 22, it's allowed, Lordship.
Mentioned, I won't be able to take. I'm really sorry because that procedure has been given. Then I cannot change the procedure. This is decided by a committee. Decided by a committee, and then
But in my case, Lordship, already mentioned.
that
it's allowed.
Podar will know better. Podar is there. He will know better. These are all decided by a committee. He will know better. He was always in the registry. Can I change the procedure, notified procedure? He will know better.
No, I am standing in the queue for a mention. I may be expecting Lordship, no comment, please.
Anyway, my lord,
As I am standing on
my lord, may I make a mention, my lord? Item number 10 of your lordship carbon list, my lord. I crave leave to, my lord, withdraw that petition, my lord, that may be
Okay.
allowed.
This will be allowed. Item number 10.
10.
Learned Council mistake.
My lord, no unlisted mention is permitted below.
No. Through email.
Lordship,
Procedure, notified procedure.
That is there, my lord.
Upload
No,
कर देना, TV to, हाँ? TV to upload कर दिया.
my lord, that is there.
Where he went, where is Podar? He will help.
But
Lordship, in
Podar is very best person who can
my
help.
case is little different.
What are you tell them who decided
He is the best person to explain, my lord.
Please excuse me, my lord, I am not.
my lord,
Lordship.
he was in the registry.
my petition will become infractuous, my lord. On 4th of
This is an AB or a BA.
My lord, actually,
AB or a BA.
I am directed to appear before this tomorrow, Lordship, before the police station.
Oh, did that?
But PD9, the Learned Council, PD9.
My lord, already in the
difficulties
list,
for-
was this is mentioned.
Why you-
Doesn't matter, maybe
Yes, no.
10:30.
I have applied yesterday through email. I have done all the requirements.
Hmm.
My lord, there is
All
one thing that
of
seems.
which were rejected. They were considered thoroughly that they are not very important, and so they were rejected. All the items which were sent through email and rejected. So you see, and then because another bench, another 3 benches will be sitting on 10. So this was also taken into consideration and rejected. And we suddenly on 10th, please go. No, not on 10th. On 14th.
You have to fix it 2 days.
On 14th. 60 days will be over.
No, monsoon, my lord, it will be around 57 days.
Call for the CD, list the matter on
14th.
14th July.
Obliged.
This is the lordship. Part 483 application and the petitioners behind the bar for last 3 years, 3 months, 15 days. At this stage, my prayer is to call for the trial court records, my lord.
Call for the trial court records, call for the scan copies of the trial court records along with the scan copies of the CD, list the matter on 21st July.
My lord, let it 15th or 16th, if possible, 15th or 16th. 18th. 18th, my lord.
May I please your lordship? It's 483 like application, my lord. I was defaulted into appear before the court, my lord. And from my lord, 13/12/24, I am behind the bar last 6 months, 17 days, my lord. My lord, I have, but in every date, my lord, my lawyer has filed an application for adjournment, my lord. But lastly, my lord, on 24/4, the non-bailable warrant was issued without issuing the summon. Directly non-bailable warrant. Then PNA. Then I was taken into custody on 13/12/24. Since then, my trial is going on. 2 witnesses have examined. I have annexed matter. They said that informant and I could not identify the person. My lord. 46 and 45.
Such that case, my lord, can you be called from? Such that case.
Yes, charge sheeted case. My lord. I defaulted to attend the court. I was on bail. But my lawyer has filed an application each and every day. My lord. Kindly allow me to participate in the trial.
No, my lord, if my learned friend wants to, my lord, argue, my lord, we'll have to, my lord, submit certain things, my lord.
Yes, submit.
Lordship may kindly come to my lord, page number 27, my lord.
Yes, I have already told, page
My lord,
27.
he has been declared as a proclaim offender.
Yes, what do you mean a proclaim offender? What do you mean? Directly can the court declare proclaim offender?
Shouting will not
Non-bailable
be
warrant proclaim
by
offender
record, my lord.
without execution of the
He
order.
has been declared in proclaim offender, my lord, and he has been arrested in an NDPS case, my lord.
Yes.
Another NDPS case, he has been arrested, my lord.
My lord, I have
Now,
been
my lord,
enlarged
since
on
he
bail
has
in
been
that case, my
declared
lord.
proclaim offender, my lord. Now he has been shown arrest in this case, my lord.
Not shown, my lord. I'm sorry. It is because of the warrant of arrest, I was taken into custody.
This can be maybe called from.
Scan copies of the trial court records along with the scan copies of the CD. List the matter on 21st July. Item 5.
May I please? But 483 application, my lord. The petitioner is grant the bar from my lord 27/5/2025, my lord. Initially, my lord, the case was registered under section 137, subsection 2 and section 3, subsection 5 of my lord, BNS, my lord.
Poxo, my lord. That will have to go.
Subsequently, my lord, section 4 of POX has been added, my lord.
Will issue notice to the respondent number 2.
My lord.
Petitioner to take heard learned counsel Mr.
Yes, Islam.
J. Islam for the petitioner. Full stop. Learned additional PP Mr. Heard, comma. Learned additional PP Mr. R.J. Borua for the state. And liquid comma and liquid and petitioner to take steps to issue notice to the respondent number 2 returnable on 25th July.
My lord.
Meanwhile, call for the CD.
My lord.
Investigation is going on.
My lord.
Call for a
Yes,
CD.
for 23rd July. Case died. Case died.
Item 6.
Right, my lord.
The petitioner is in custody since 28/5/2025, Lordship. As on today, Lordship, 34 days. And FIR, Lordship, will find page 13, 11 grams of heroin was recovered from his possession. That is the allegation, Lordship. So at least my prayer is that, Lordship, that considering the quantity and detention period, Lordship,
We will call for a CD.
CD may.
that in that case,
First day.
that on 14th, Lordship.
14th. Fine. Call for the CD, list the matter on 14th. Item 7.
All right.
Please, your lordship, this is the NDPS matter, lordship, offense under section 21C, and today is 95 days, lordship. So CD may be called and matter.
Call for a CD or trial court?
CD, madam.
CD.
No, Sasi not yet filed.
Then 95 days.
Call
today.
for the, there may be prayer for extension.
Yes, madam.
Maybe, no?
Maybe, madam.
Call for the CD, list the matter on.
Short date may be given.
It will come out. Following up, madam.
Much.
Item number 8.
Here in this case, lordship, what has happened? My lord, I have the instruction to, in this case, I have the instruction to appear for the respondent number 1. My lord, I say that let a copy will be served to me and it may come up after the execution.
Yes.
Lordship, then in the meantime, the proceedings may be straight, lordship. My learned friend is appearing in this case. So the proceeding may be straight because what has happened in a divorce matter, the parents and all the relatives have been added as a party to the proceeding, and there is no relief claimed against those defendants. So we have been prejudiced, and that's why I filed an application for this deleting our name from the array of party, and that has been rejected by the learned trial court, lordship, that considering the relevant aspect of the provision of Order 1 Rule 10, and I have annexed the application, lordship. It is there. The lordship kindly see the page number 16, annexure 1. In this case, they have page number 16, annexure 1. It's a petition under Order 1, Rule 10. It is fixed for issues. So nothing will happen by the next deadline. Lordship, thing is that, lordship, the thing is that if the matter goes on without any stay of the proceeding, then end of the day, if the court finds that I am not, this order is sustainable, otherwise, then we will be in a position not to file the written statement because of the time period. Because why I'm saying so, lordship, because these particular lordship, what has happened in this case, these petitioners have been added as a party to the proceedings without seeking any relief against them, lordship. What is the purpose of the father? What is the purpose of the mother? And what is the other relatives? If your lordship kindly see page number 16, annexure 1, my application for deleting our name. Lordship, kindly see page number 16, annexure 1. Page number 16, lordship.
Yes, yes.
That the petitioner files this instant suit under section 12 of the Hindu Marriage Act, and as such, no party can be added as respondents other than husband and wife to the voidable marriage, which is sought to be declared null and void. Now, the petitioner, that means the respondent herein, she is claiming by that particular application to declare the marriage as void. Now, in the next page, lordship, kindly see page number 17, annexure 2. That the respondent number 2 is the father, 3 is the mother, 4 and 6 are the sister, 5 and 7 are the brother-in-law, 8 is the paternal uncle, 9 is the first cousin. So these are all the relatives. What role they are having in that particular marriage and what sort of relief she is claiming. She is claiming relief for the declaration of the fact that the marriage is null and void because of certain issues of the husband. Now, since the issues of the husband is there and she can very well prove it by way of adducing evidence, what these other persons will do in this particular proceeding. So this proceeding, impleading these persons, the petitioners is absolutely because of some malified intention, lordship. So that is the reason why lordship filed an application for deleting their names, and that has not been taken into account by the learned trial court. If you want to kindly see the order, the impugn order by which that application has been rejected. It is at page number 31, lordship. Paragraph number 15. Furthermore, this court as a civil court is obligated to hear from all parties against whom allegations are made in the pleading. In the present case, the petitioner has attributed specific allegation against respondent number 2 to 12. If the court were to dismiss their names at this stage, it would lead to prejudice in any determination made upon the conclusion of the original suit. Now, what is the prayer in the particular application, lordship? Prayer is, I'm just reading that prayer. I have the call for that necessary this additional affidavit. In that particular petition for dissolution of the marriage, the prayer, the dissolution of the marriage between the petitioner and the respondent by granting a decree of nullity by dissolving their voidable marriage fraudulently solemnized on 30/4/2024. This is a simple case of dissolving the marriage on the ground of this fraudulent solemnization on 30/4/2024. Now, what these persons will do and how this will affect the case of the wife in that particular divorce proceeding, lordship. These are nothing but abuse of the process of the court, lordship, and their presence is at all not necessary in proper adjudication of the issue, lordship. Because this will come up on the basis of the evidence on record. The court may very well pass an order on the basis of the materials that would be available on record at the relevant point of time, lordship. And that is the reason why, lordship, the application has been filed, but that has not been considered in a proper way, and technically that has been rejected, lordship.
Given the order, my lord,
Yes, yes.
passed on the last, my lord, they have to submission of the statement already rejected. Today is the fifth date for issue. On the next day, at best it will be for filing plaintiff's evidence. Nothing will happen, lordship may issue notice on the next day, fix it on 14th, my lord.
No,
On that
if
date,
nothing happens, lordship,
because,
then
my lord,
why?
they have not submitted the written statement. What prejudice will be caused?
No, I
And
can
will
understand
satisfy
that. Then
with
why the,
there is allegation against each of the petitioner and that they are impleaded with the region, my lord. I will satisfy your lordship, let him serve a copy. Let it be taken upon 14th, my lord.
no,
Because
lordship,
your
what has
prejudice is
happened
going
in
to
this
be
case, he can satisfy this honorable court. But the fact is that, lordship, since I have been added, these petitioners have been added in this case, and he is saying,
They mentioned stage, isn't it?
lordship,
Motion stage.
motion state, lordship.
We'll hear at the admission stage.
Exactly, lordship. Till that period of time, this proceeding may be stayed, lordship. I'm not saying that this will continue for a long period of time. Till that period of time, the proceeding may be stayed. And this matter may be fixed out immediately after vacation.
They only want to delay the process because what is the issues then, my lord, plaintiff's evidence. What prejudice will be caused?
Then why we have been made parties in the proceeding? We have been unnecessarily added as a party to the proceeding,
They
lordship.
have even not submitted the written statement.
We have been unnecessarily added as a party to the proceeding. There is a procedure for adding party. If you are not,
That lordship will decide.
if you are not claiming any relief against the other defendants, then why they have been made party? Merely adding party, it goes to show the malified intention on the part of the petitioner. She is not otherwise claiming any relief against them. She is not asking for any compensation, nothing of that sort. She is asking for dissolution of the marriage. The dissolution of the marriage, the husband or wife is the parties. The other relatives, father, mother, and even the lordship, kindly see the page number 17. Even the person who was the mediator for that particular marriage, he has also been added as a party. So all persons who came and joined this particular marriage, everybody was added as a party to the proceeding, lordship. And they have been unnecessarily harassed by this particular proceeding. And that too, this application has been filed after the husband filed the application for divorce. Thereafter, as a counter plus to that particular divorce application, she filed another application for dissolution of the marriage. In the additional affidavit, I have annexed both the copies, lordship.
Who is the husband?
Lordship, the husband is the pro forma respondent here, lordship.
These are all the pro forma respondents.
Yes, lordship.
Husband is not a party in this appeal.
No,
this
lordship.
petition.
Because the application was filed by the petitioners, lordship, for deleting their names in from the area of parties, lordship. Pro forma.
Respond number 2.
Pro forma. I made him as a party, he's a pro forma respondent number 2.
To declare a marriage as null and void.
Exactly, lordship.
So this is not a divorce petition.
This is for nullity.
Nullity.
For nullity.
Nullity.
So only in a divorce petition, husband and wife are the relevant parties, but nullity is somebody.
For nullity for dissolution of the marriage, lordship, and they are not seeking any relief.
This is not
They-
resolution of marriage.
Exactly, lordship. Kindly see the prayer portion in that particular application, lordship. I'm just reading. For a declaration of dissolution of the marriage. Dissolution of the marriage between the petitioner and the respondent number 1 by granting a decree of nullity by dissolving voidable marriage fraudulently solemnity on such and such. Now, how these other relatives will do with regard to that? How they will give any sort of relief to the petitioner? Because if you are asking,
They may be necessary parties.
Lordship?
You never know.
lordship,
They may be necessary parties. You never know.
no. If you are not seeking a relief against the other defendants, then why they should be added as a party? That is my submission, lordship. If you are not seeking,
We'll get
because
to know. Let us hear at the date of admission.
exactly, lordship. Since my learned friend is appearing, lordship, till that period of time, the proceeding may be stayed, lordship. Otherwise, this proceeding will go on without any result, lordship. At the end of the day, if the court comes to a finding that these persons have been added or these persons have been added with certain irregularity, then what will happen, lordship? At certain point of time, the proceedings will go on. So till that period of time, the proceeding may be stayed, lordship.
Nothing, this is not required actually. Stay is not required. Why I'm saying stay is not required? You do not want to proceed. So even if they are proceeding against you, you are not appearing there. You are being represented by your advocate. So you do not want to proceed. So you don't have to go and
No.
appear.
No, lordship, I am saying so because if the petitioner or the wife is not claiming any relief, then what is the use of adding all the persons as a party to
We
the
get
proceeding,
to
lordship?
the stage of admission.
Lordship.
Now you don't have to, now nothing, there'll be nothing against you. You don't have to appear. This is not a criminal case.
No, we don't have to appear, but the thing is that there is a procedure under the CPC, Lordship, because
It will be
if,
disposed of.
Lordship,
It will be disposed of.
exactly till that period of time, the proceeding may be stayed, Lordship, because
Why?
the issues will be framed, certain things will be there, certain things will come up, Lordship. This may some way or other prejudice the interest of
Affected will be the husband.
Lordship.
Whoever will be there, whoever will be affected.
Exactly, Lordship. The husband, then why the other persons have been, there is no explanation with regard to that. Why these persons have been addressed as a party to the
If
proceeding.
the husband is not affected by this petition, what is the point of staying? Not required.
Lordship, because the application was filed by the person.
No, I
who
don't
have-
see any ground to stay. You see, I don't see any ground to stay. You see, you are the case is between you and the husband. Whatever benefit she's claiming against your husband. There will be no harm caused to you or you won't benefit.
No, that
If
I
you are-
understood, Lordship.
Eh,
But unnecessarily, I have to be present, remain
if you
present in the proceeding, Lordship.
be affected or you won't be benefited. So what is the point of staying? Let's not stay. We'll hear it.
Then after vacation, Lordship.
Yes. Earliest after vacation. We may not need the records also. We'll hear.
No, I have already annexed all the petitions, Lordship. So
He is also saying, see, we'll expedite the procedure. He's saying records are not necessary.
Not required.
So not required.
no, I'm not praying for record, Lordship. What I'm saying that till the period of time this proceeding may be stayed. Why I'm saying so, Lordship?
Find any ground. You'll neither gain nor lose anything. Learned Counsel, Mr.
SP Chaudhary.
SP
Chaudhary.
Chaudhary is present for the kiman number hoito? Your wakalat nama you have submitted.
My wakalat nama is there.
Mr. SP Chaudhary is present for the petitioners. Learned Counsel, Mr. AK Gupta is present for the
For respondent number 1, I have filed the wakalat number.
for respondent number 1. Issue notice to the how many respondents we have?
2 respondents.
Issue
One is pro forma, one is the main respondent.
petitioner to take two steps to issue notice. You represent the pro forma respondent.
No, he cannot represent, he's the
I have for
husband.
the wife, his husband.
Okay. Issue notice to the pro forma respect is not required there. Husband.
It's a formal party.
He not required.
Nala issue notice to the. We won't issue notice, then we will fix it. It appears that notice is not.
Notice may be issued since he is representing for the respondent number 1. So we may copy and the matter may be fixed for admission on the returnable date.
Petitioner to furnish a copy of the petition to the respondent number
1.
1. It appears that this matter may be fixed for admission for speedy disposal. List this matter for admission on 23rd July. Item 9.
May I please, your lordship, your lordships, in this case, the respondent has filed a suit for declaring of their right under Raiti Khatiyan, your lordships. Raiti Khatiyans. In this case, what when your lordships own Mahipunu Begums was the owner of a plot of land measuring 5 biga 1 kata 3 lesser. And under that, your lordships, the respondent here in claiming that their predecessor was the Rayat. And as he is the legal heir, so he is also the Rayat. So this is basically their case. They are claiming their right on the basis of Rayat. In this plaint itself, your lordships, at para 4, page 26, your lordships. Achha, before that, your lordships, they are claiming because of the Rayatship, they are in position, your lordships. But they admitted in para 4, your lordship, page 26. Plaint. So the plaintiff stated that on 23 to 2009, the name of the Majida Begum, the petitioner here in your lordships, has been mutated in respect of the entire land under Dag number 363 of Kepipata number 92 of the village Pachim Nagaon under Moja Goba Mayang Binu Circle in the district of Morigaon, Assam by way of exchange. And on the strength of said order, the Majida Begums owned the land under Dag number 363 and Kepipata number 92. She has been arraigned as a defendant number 1 of this instance case. So, Your Honor, my case is that I got that land by way of exchange from Mahibur Begum.
By way of
Exchange,
exchange. Okay,
exchange.
yes.
In exchange of this land, I have given another land. And this part is also admitted by the defendants. Problem here, what happened here, lordships, being a riot, they are claiming that they are in possession. But what happened in this case, your lordship, I am in possession of this land since the day of this exchange and prior to that also, your honor. And now I am Patradars, as my name is appearing in the Jamabandi, your lordship, and mutated in my favor, your lordship. And regarding possession, your lordships, there is a, so your lordship, my contention is to show that I am the Patradars as of now. And the respondent is claiming that they are the righty. But it is about the possession, your lordships. Page 73. This order is a circle officer, Mayang Revenue Circle. She reported to the Additional Deputy Commissioner Revenue, your lordship. Page 73. With reference to subject cited above, it is respectively stated that before your honor that as per the report submitted by the Concerned Lord Mandal, Kanungo of this circle, in connection with the prayer made by the Majida Begum, daughter of late Muslim Begum, Moja Gawa, district Morigaon, for striking out the name of the riot, respondent hearing, your lordship. With respect to the Khatiar number 18, it is found that the name of the Baku Khal Lalungs and son of late Betarang Lalungs has been recorded as a riot as against the said Khatiar. With respect of the land measuring 5 biga 1 kata 3 lessa covered by Dag number 363 of KP 92 of Paschim Nagaon, Moja Goba under Mayang Revenue Circle in the district of Amrut, in the district of Morigaon, Assam. On field survey, you're very important. On field survey, it found that said land is not under the possession of the river. The entire land is under the possession of the Patadar. Patadar means, your lordship, I am petitioner. So, your honor, this report is there that I am in possession. But the plaintiff has filed a suit and praying thereon, your lordships, page 23, although I am in possession, since the day of exchange and prior to that also, exchange admitted by the respondents. In page 32, your lordship, in their plaint, they pray for confirmation of possessions. And setting their case that they are in possession of the land. Whereas circle officer, the report of circle officer says that I am in possession, your lordship. On the basis of that, they filed the suit. I filed an objection in injunction, your lordships. And injunction application was disposed of, your lordships. Page 82. So, your lordship, herein it's a question of possession, your lordship. Who is in possession? Circle officer report is that I am in possession. They claiming they are in possession. I am also claiming I am in possession, your lordship. So there is a question of possession only. Now, the trial court, your honor, page 82. Most particularly, your lordships. Last one, no? Your lordship, page 92. Order is start from page 82, page 92. The page 92, para 27, when the learned trial court has given their findings. Found it, lordship?
Yes.
Upon meticulous perusal of the pleading of the parties, the documents submitted in, and also after hearing both the parties, it disclosed before this court that the petitioner plaintiff filed the suit for right title, interest, confirmation of possessions, and permanent injunction. The defendant has filed written objection denying the allegation made by the petitioner plaintiff. Plaintiff petitioner has been stating that the petitioner of their predecessor late Bakukal Lalung as a riot under the landlord owned by Mahibul Begums are cultivating over the suitable A land without any disturbance from the landlord, any other persons, and they are paying the half of the petty rice produced in the year to the Eastwell landlord or his family member. On 23/2/2009, name of the Majida Begum has been mutated in respect of the entire land under the Dag number 363 of KP 92 by of exchange. And on the strength of said order, Majida Begum on the said land under Dag number 363 of KP 92, though the opposite party number 1 become the landowner of the opposite land, but the petitioner has legal heirs of Baku Kulkhang Lau as riot has been cultivating petty rice over the Sulu land. On the other hand, the OP denied all allegations and stated that the plaintiff petitioners are never in possession of the land. In fact, the OP is in possession of the land, therefore dispute. So prima facie case is decided. Now the balance of convenience, Your Lordship, the page 32. Before making any comment on the balance of convenience, first I have to ascertain who is in possession of the suit property at present. The meticulous perusal of the pleadings, it appeared that both the party claim to be in possession of the suit land at present. However, it appeared from the record that the plaintiff has been filed the suit for confirmation of possession. Thus, it can presume that they are in possession of the suit land only because they pray for confirmation of possession. So the court come to conclusion that they are in possession. Whereas there is a report of circle officer where it says that the right is not in possession, the patadar is in possession. Perhaps it's illegal finding, wrong finding, Your Lordship. On the basis of this finding, Your Lordship, Your Lordship, see the situation. I'm in positions. Circle officer say I'm in positions, and the order passed. This is the main finding, Your Lordship, regarding position. The order passed, Your Lordship, by the trial court is page 95. And most page 95 and to 96, Your Lordship, 96. Opposite party dependent are restrained from entering into the suit land, from alienating the suit land, disposing the petitioner from the suit land, and also damaging the crops, Your Lordship. Whereas I am in position, Your Lordship, it's a case of prima facie stage. In the deciding the injunction, Your Lordship, evidence has not to gone into. So prima facie I am in position. The report of the circle officer is in my favors. I says thereafter also, Your Honor, the trial court says I have been restrained from entering in the suit land, whereas I am in positions. Okay. On the strength of this Your Lordship orders, now they are going to dispose me from the property, Your Lordship. Before deciding the suit, I am being non-suited, Your Lordship. So prima facie, this is illegal order. Thereafter, Your Lordship, against that order, I file an appeal, Your Lordship. And in appeal, Your Lordship, notice was issued and order was passed, Your Lordships. Page 129, Your Lordship, imping order. Your Lordship, most particularly your 130, Your Lordship, page 130, the reason starts. Actually, what happened, I filed an appeal, Your Lordship, under 43 rule honor, along with an application under 41 rule 5 of the CPC for staying the order, Your Lordship. So the your finding of the trial court, page 130. Second para, Your Lordship. Internal page 2 of the order. On perusal of the written statement, written objection filed by the defendant, Your Lordship, page 130.
130 or 111?
130. 130.
130, which page? Which paragraph?
Your Lordship, the second paragraph, 130.
No second paragraph. I think there has been some wrong.
Your Lordship, the imping order. Last order, Your Lordship. 21/6/25. Last 2 page, Your Lordship. 3 pages.
21/6. I'm telling you, it's page 144. Page 144. Order dated 21/6/2025.
21/6/25, Your Lordship.
Second paragraph. Okay.
Your Lordship, second paragraph, the counsel of the appellants have stated that they are in actual possession of the suit land, which is proved by report of inquiry dated 24/24, which I have referred already, Your Lordship. Report.
Yes, you can read it, yes.
Made by the circle officer, Mayang, wherein it has stated that the LA suit land under Dag number 92, 363, and Dag number 363 of comprising 5 biga 1 kata 3 lasa is in possession of the Patada. Patada means petitioner, Your Lordship. With further suggestion that the name of the respondent be struck up as a riot from the suit land. Learned counsel further submitted that the order of the learned senior civil judge, Unit Division 2, prima facie erroneous. In the case of that, the learned civil judge, Unit Division number 2, almost gave a finding that the respondent plaintiff are in possession of the suit land, which is beyond the jurisdiction of the court, which decided the injunction petition. On perusal of the written objection, statement written objection filed by the appellant defendant, that the suit number so and so, it appeared that the defendant have taken the plea that in the last part of August 2020, they become surprised to know that the late Bakukung Lalong predecessor interest of the respondents was the right under the Mahibanu Begum. The appellant has also alleged that the fact as was suppressed by the Mahibur Begum at the time alleged exchange of the suit land with the land of the dependents, and accordingly they filed an application before the Sagu Mayang with prayer to strike out the name of the Bakukung Lalung as Rayat from the suit land. On the basis of that opposite application, the circle officer Mayank submitted a report that is so-and-so stating that the appellant are in actual physical position of the suitland, not the plaintiff respondent. And the defendant have also stated that they are contemplating to file the separate suit against the Mahbub Begum, challenging the executive validity of the alleged actions done by her through her husband, so-and-so. Let now devolve upon the order passed by the learned civil judge, Unit Division number 2, decide whether the operation of the injunction petition need to be stayed at the initial stage of appeal. It observed that the learned civil judge, Unit Division number 2, in major case so-and-so passed an order restraining the appellant from entering into the suitland along with other directions. The court below gave the finding that the plaintiff respondent are in possession of the suitland. The learned court below also gave the finding that all the three ingredients, prima facie, balance of convenience, table loss injury, has been established. In the light of above, it appears to me that the main contention of appeal praying for a staying operation of the injunction petition is that they are in actual physical position of the suitland, and civil judge Unit Division 2 has wrongly appreciated the fact holding that the plaintiff are in actual physical position of the actual position of the suitland. Plea taken by the plaintiff is that in the year 2023, they come to know that the predecessor interest of the plaintiff has got his name recorded as a riot in the court of rights, the court of the suitland. Immediately, they prayed for striking out the name of the plaintiff as a riot from the record. Appellants have relied on a letter issued by the Sagovisa Mayang, in which it has been categorically stated that the land in possession of the Patadar, not the riot. Based on the same, they have disputed the finding of the learned circle office, learned civil judge in division number 2, that respondents are in possession of the suitland. In this regard, it is stated that the letter of the circle officer cannot be considered as conclusive proof to decide as to who is in possession of the suitland. It is well settled, it will known fact that the revenue department has to undergo a serious process of issuing notice to all affected party and then taking necessary evidence before coming to finding final finding as to who is in possession of the suitland. Finally, come to conclusion regarding correction of the land record. Apart from the aforesaid, the document the appellant have merely relied on bare statement of the WSN objection. In order to give a stay on the operation of the order injunction, it is necessary to prove on the part of the appellant with sufficient prima facie material that the order passed by the learned so-and-so as alleged unjust, and face of it, I am of the considered opinion that the appellant at this stage has merely relied on the pleading of the opinion of the circle officer so-and-so. Based on same, it cannot be held that the order of injunction given by the trial court is a prima facie unjust, illegal, and require immediate intervention from this court. Therefore, rejected. So, my humble submission, your lordships, at the stage of prima facie stage, what more is required? To establish my positions, I have not to give evidence. It is only the position part is important, and the supervisor say I'm in position. I'm also there, I'm in position. They are claiming that they are in position. Now, if the restraining order in your operations, what will be happening? Your lordship, petty situation is already on, your lordship. So, my humble submission, your lordship, the order of the trial court as well as the appellate court is prima facie wrong order. So, my humble submission, your lordships, this may be a state, and this CRP may be admitted, your lordship.
I'm telling you something.
Your lordship.
It is already observed that you are not that you are in possession by the civil judge.
Your lordship.
So you won't be removed.
No.
So stay is not required.
No, restraining order, your lordship, this is the problem. Restraining order is there. Restraining order is there. Had been the order that status quo may be maintained by both the party, then situation will be different.
Then I'll pass an order to maintain the status quo.
That order may be passed, your lordship. That order may be passed.
After I come back?
Your lordship.
Item number 13. Could it be taken after this, I think, Lordship,
Yeah.
after 2, because I have a very important government meeting at 3 o'clock.
Okay, okay. All right. This won't take 5 minutes also.
No, no difficulty. 1-3.
All right, can be taken.
That's all right.
Highly.
Honored Counsel Mr. Vijayan Jha for the petitioner, Mozira Begum, who has filed this application under section 287 of the Constitution of India. For issuance of a writ of maintenance, writ of certiorari, or any other appropriate writ or order. To set aside and quash the impugn order dated 21/6/2025, passed by the learned civil judge senior division in Miss J, case number 25 of 2025, arising out of Miss Appeal number 4 of 2025. It is submitted on behalf of the petitioner that she was the defendant in the title suit number 104 of 2014.
Yes, Your Lordship.
The plaintiffs have prayed for confirmation of title,
Possessions, identity.
confirmation of possession. Over the suit land described in the schedule of the plaint. It is submitted on behalf of the petitioner that the plaintiffs were earlier were legal heirs of a holder of Riot Khatia.
Yes, Your Lordship.
Legal heirs, no? Legal heirs of holder of
Lalu.
Khatia over the plot of land mentioned in the plaint. Full stop. Meanwhile, on a deed of exchange, the defendant, i.e. present petitioner, took possession over the defendant or his ancestors.
Dependents.
Defendant herself
Hmm.
took possession over the same plot of land over a deed of exchange, you know?
Yeah.
Deed of exchange. It is specifically mentioned in the plaint
Yes, Your Lordship.
about, it is specifically mentioned in the plaint that the defendant and there was a deed of exchange executed, specifically mentioned in the plaint that there was a deed of exchange executed between the plaintiff's father or the plaintiff themselves, between the plaintiff and the defendants.
No, plaintiff and Your Lordship, Mahiburu Begum. Plaintiff and Mahibaru Begum, the original.
Plaintiff and Mahibur Begum.
Mahibaru Begum. Mahibanu Begum.
Mahibaru Begum. Plaintiff and the defendant.
Dependent not. Mahibanu Begum, the original Patadar.
Mahibanu Begum, i.e. the original Patadar. It is also an expiry. It is also further submitted that the circle officer had, where is the certificate?
Yes, 73, Your Honor. First para last year also.
That the circle officer had submitted a report to the additional deputy commissioner that the present petitioner was in possession over the suit land.
Land.
So then the deed of exchange will be executed between whom?
Between the original patadar, Mahibanu Begums, and me.
ক'ৰবাত কিবা এনেকে হেৰি চাই ল'ব দেই আগতে কিবা এটা ডিক্টেশ্যন দিছে নেকি উল্টা পুল্টা চাই ল'বাচোন It has also been observed by the that sessions court's order, that appeal order
Appellate
against
order,
the injunction order,
page 46, injunction order, Your Lordship.
not the injunction order.
Appellate of court orders,
Let-
146, Your Lordship. Imperial order.
It is also submitted that by order dated
21/6/25.
21/6/2025 passed by the learned civil judge senior division
Morigaon, Your Lord.
Morigaon in an appeal preferred by the present petitioner against the order of the learned civil judge junior division in mid-J case number 141 2024. It was held, it was observed, it was observed that it was observed that page 146, it was observed as below page 146. A tick mara paragraph kita likhi diba, page 146 of the petition. Page 147 allo jabage. Tick mara paragraph likhi diba. Next paragraph, but however, despite this observation, the appeal was not allowed. I have considered the submission set apart. The appellant was the petitioner. The petitioner was directed to vacate the suit premises, which is the subject matter of the title suit number. What is the number of title suit?
104.
104.
104.
The learned civil judge senior division has with an in-depth discussion held that the appellant that the petitioner is in possession of the suit land. Considering all aspects, both the parties are at present directed to maintain status quo till the next date of listing. Issue notice to the respondents.
Your Lordship.
Returnable within 4 weeks.
Your Lordship.
Call for the scan copies will be better, I think.
Your Lordship.
Scan copies will be better, no?
Your Lordship. Orders. Scan copy.
Scan copies.
Scan copy.
Scan copies of the trial court records.
Your Lordship, status quo in
List
such a
accordingly.
position.
Till the next date of listing. list accordingly.
Your Lordship, status quo in respect of possession.
Status quo as of today. They are not vacated, no?
In respect of possession.
In respect of position, okay.
Which will-
Incorporate scan copies of the trial.
Yes,
court
yes,
records.
yes.
Item 30.
My lord, the matter relates to my lord selection and appointment, my lord, under the Oil India Limited, my lord. My lord, an advertisement was published, my lord, to recruit, my lord, for work person in various category under the Oil India at Duliajan, my lord. Your lordship will find the advertisement, my lord, page 43. Page 43 is the advertisement, my lord. The requisite criteria, my lord, the selection methodology at page 47. Now, these are the, my lord, requisite criteria to recruit the work person, my lord. And my lord, after fulfilling all these requisite criteria, my lord, the petitioner, my lord, submitted their form online, my lord, online form, my lord. My lord, after my lord scrutiny, my lord, they were called for to appear in the, my lord, CBT.
Requisite criteria, which page?
Requisite criteria, my lord, selection methodology at page 47.
Okay, okay, all right. Yes, yes.
These are the, my lord, requisite criteria. After fulfilling all these requisite criteria, my lord, and these were, my lord, accepted, after scrutinized, my lord, the petitioners were called for to appear in the, my lord, CBT, computer-based test, my lord. And they appeared, my lord, and my lord, they successfully passed, my lord. But the result sheet, my lord, the merit list, my lord, that was, my lord, published, but they were not in the merit list. My lord, and the ground, my lord, which has been, my lord, stated, that is the result of the petitioner, my lord, at page, my lord, 106, my lord. 106. The merit list, my lord, first of all, my lord, before that, my lord, your lordship will come at page 94. This is the merit list, my lord. Result notification. Who were appeared in the CBT, my lord, CBT test. And my lord, there, my lord, result, my lord, page 107. The petitioners were rejected, my lord, on the ground that, my lord, kindly come to page 107.
Yes, yes.
My lord, the ground, my lord, last, my lord, final result, not selected, no requisite post-qualification relevant work experience. This is the ground. For this ground, my lord, they were rejected. Overall, my lord, they, my lord, got the marks more than the cutoff mark, my lord. My lord, he got, my lord, 77. 77. And the petition number 2, my lord, my lord, he got 78, my lord. Whereas cutoff mark was, my lord, 70, 70. And the ground, my lord, the rejection, ground of rejection, my lord, not selected, no requisite post-qualification relevant work experience.
Okay.
My lord, now, my lord, kindly come to page, my lord, 45. 45. They, my lord, applied for the category of, my lord, that is at serial number 22, my lord, page 45. BGE 12023. My lord, past BSc zoology major, my lord. But they are the, my lord, zoology, MSc in zoology, my lord, both the petitioners. From a government recognized university, board or institution. Past diploma certificate in computer application, these all requisite criteria which has been, my lord, submitted in online. Even then, my lord, The ground is, my lord, mentioned, they have no relevant qualification of experience. This is, my lord, violation. My lord, the criteria at page, my lord, 45, again, my lord, come, my lord, 47, page 47. My lord, Roman 3, my lord, candidates will be called for computer-based test only on the basis of their declaration in the completed online application form. Only, my lord. If, my lord, they have, my lord, they have no some requisite criteria, then they should not be, my lord, called for CBT. And, my lord, only this particular, my lord, category, there were 7 posts. And, my lord, 4 posts are for general, and 1 is, my lord, OBC and CL, and 2 other category, reserve category. My lord, the reserve category, I do not touch, my lord. My lord, only the general category, my lord, there are 4 posts, and 4 were selected. My lord, I am, my lord, praying for that 4 posts. And 1 is NCL, my lord, OBC. So 4 plus 1, my lord, 5 posts. And other 2 is, my lord, SC/ST. I'm not touching SC and And, my lord, there is clear violation, my lord. The criteria of the advertisement. So at this stage, my lord, at least, my lord, appointment shall be made, my lord. I am not objecting, my lord. But at least, my lord, two posts has not been, my lord, appointed.
Two posts not appointed.
2 posts, my lord, has
4
not
posts
been,
there,
yes.
plus 4 plus 1,
Yes.
5 posts.
5 posts, my lord. Out of 5 posts, my lord, all were selected, my lord. At least, my lord, pending disposal of this writ petition, my lord, 2 posts shall not be, my lord, appointed.
Lordship will kindly come to page 45.
I've seen it.
No, he has not shown the main part.
I think
Lordship,
he has not shown, but I have seen.
yes, that BGE, serial number 22. First is the educational qualification is passed in BSc Geology major from a government recognized, which he fulfills. Second is passed diploma in computer application, which he has done. Now, number 3, must have minimum 3 years post qualification work experience in relevant field. That is where he failed.
No, my lord, I have, my lord.
I did not
Yes,
interfere.
yes,
If you
yes,
want to
yes,
continue,
yes.
then I can
Yes,
continue.
yes.
Because he has not touched the main point.
Yes.
Now, Lordship will come to his writ petition. Page 10. Now, what is relevant? That is the crucial aspect Lordship will have to consider. Now, he has in page 10, he has given his experience. Petitioner number 1, working experience, Director General of Hydrocarbons, handle use agencies concerned in obtaining statutory clearance and escalated major issues of state officials and HOD department. So, this BGE post, what is that post? He has not disclosed before this one. That post is Lordship, exposure to the drilling and drill cutting sampling observation. I can give a copy of it. These are the works. The first is job description of the post BGE. So exposure to the drilling, that means he should be involved with the drilling exercise. Number 2, preparation of litho column and vertical profiles based on rock sample description. Petrographic description based on thin line section study. Contour make preparation. Conventional coring during drilling. To assist geologists during drilling operation in the field. To assist other activities assigned by department. So his work is at the field. Now, what experience he has, Lordship will kindly come to page 10 now. So we want from the advertisement that he must have 3 years experience in the relevant field. That means in the field of drilling. Director General of Hydrocarbons, he has handled use agencies concerned obtaining statutory clearance and escalated majority to state officers and HOD Environment Department. So this is purely administrative work. I work in Dispur, I get pollution control board's permission. This kind of works he is doing here. So his period is 1/6/2023 to 25/1/2024. Then ANI integrated service as a well site geologist and assisted in obtaining statutory clearance. Here also he has done statutory clearance, that is the administrative work, but he is also in the well site of geologist. So his experience here, Lordship will kindly see, 22nd September till 31st of May 2023. So about 7-8 months he has experience. We have considered this because he was at the site. Then third, Assam State Disaster Management Authority, preparation and updation of revenue circle level disaster management plan, coordinated with various government stakeholders and provided humanitarian assistance to civilians affected by natural calamity. So during flood affected areas, he went and served. So these two, 1 and 3, will not come under the relevant field experience. The relevant field experience will come from ANI integrated services, which he has done for about 9 months. So 3 years he could not fulfill. Then same with petitioner number 2. Dibrugarh College, he was working as an assistant professor. So teaching experience we do not need. Then second, Dibrugarh University project officer at TEPIC 3 project at Dulet. Dibrugarh roles include office administration, project management, teaching, learning. So this is also not considered. Third, ANI integrated service, which we have considered. Here also his service is not more than 22nd of September 2022 to 5th of October 2023. So 11 months. Next page, Lordship will see. Oil field instrument working as mud logger roles, including real-time monitoring of field parameters at website. This is 2 months. So 2 months plus 9 months will be 11 months. So we want 3 years experience in the field.
Yes.
So even if he has done well in the CBT test, we have finally analyzed at the last moment, we have analyzed all the credentials, and his credential that he do not fulfill that eligibility criteria. And the law is well settled that eligibility criteria in a recruitment process cannot be diluted. If we dilute him, that 11 months field experience we have considered, then that would cause prejudice to many other persons who have not applied. Today, I am having 2 years experience in the relevant field. When I see the advertisement requires 3 years, I will not apply. So we cannot dilute that. For him, we cannot be very soft. We have to implement the same parameters, same yardstick for all candidates. So when we have realized that he does not fulfill 3 years qualification or experience in the relevant field, he has miserably failed. So that is the position we have already selected. Now this repetition is also bad in law. It is not maintainable because he himself has said 4 persons were selected. If tomorrow Lordship gives him relief, 2 persons will be adversely affected. They are not parties in this repetition. So because of non-joinder of necessary parties, repetition is not maintainable. Let him first correct this repetition if he really wants to pursue this proceedings in future. Otherwise, without the adversely affected party, that means 4 persons we do not know who are those 4 persons. Those names are available. If he had asked, we would have given him. So those parties are not there. If Lordship is pleased to come to see the clause title at page 5. At 4 stars, the petitioner Rupam Hendi and Devasys Nath. So these 2 persons are the representatives, and the other parties are all these official respondents, no private parties. So if he had challenged the selection of the other 4 persons, they should have been made parties here.
Yes, definitely.
So on that ground, Lordship, no interim order may be passed at this stage.
Yes.
My Lord, I do not have any grievance on the private respondent. My
But
Lord,
they'll be
my case
affected,
is, my Lord, only the violation of the requisite
but they'll
criteria.
be affected
My Lord,
if-
kindly come to page 64. My experience certificate, my Lord.
Page
Page 64. 64. This is, my lord, disaster management posted at Tengakhat, my lord. My lord, kindly come to page, my lord, for 67, my lord. As per
Maybe,
this,
maybe you have a case.
my lord, as per this
Maybe
advertisement, my lord, this is the zoology background, my lord.
Them as parties. The other party, the other
Private
candidates,
respondent.
other candidates, you
Selected
impede
candidate.
them as parties. Maybe you may have a case.
We
3 years.
we do not have any grievance upon the, my lord, private respondent.
It's
Our allegation is not against them, my lord. My lord, for a moment, my lord, kindly come to page 64. This is my
they ask for 3
experience
years
certificate,
experience.
my lord.
3 years experience.
This is pertaining to zoology, my lord. My lord, kindly come to page 67. As per this advertisement, my
You
lord,
see, 3 years experience is
here
relevant.
clearly mentioned, my lord. Does BHC in zoology. My lord, kindly
So,
come to
no,
page
but you see,
67.
stay.
And this
don't-
is,
no.
I have the
No,
experience
no.
certificate, my lord.
We will issue notice.
My lord,
All
at
the
this,
parties are here. No stay. Face of the record cannot grant stay.
my lord, kindly
See,
come
3
to
years
page
experience
67, my lord.
relevant.
67. This is one of the advertisement, my lord. As pursuant to this advertisement, my lord, the petitioner number 1, he was appointed, my lord, as a in the office of district commissioner, my lord, Dibrugarh, my lord.
It's okay.
Here is clearly
You-
mentioned the essential
Later
qualification.
on, maybe
Don't
yes. But
have
prima
to, my
facie,
lord.
no stay can be granted. No,
No,
sir,
they
it's
have the,
very
my lord,
apparent on the face of the record. So you issue notice to all these.
they have, my
all
lord, more
India-
than 3 years experience, my lord.
The central government, there will be a department that CGSC will take notice.
I think notice is.
Otherwise, my lord, my
Lordship will give one
my lord.
protection that the selection or appointment will be subject to final outcome of this recruitment. That protection he may, Lords may give. Otherwise, also that protection is always
That
there.
will be after hearing.
Yes, Lordship.
No, my lord, I have the experience certificate, my lord. The ground of rejection of my candidature, my lord, not the relevant
Today is at the motion stage, isn't it?
experience certificate. I have the experience certificate. I have annexed. I have, my lord, uploaded along with my form, my lord.
In the relevant
With-
field, no? That at least.
No,
the
my lord,
extra
kindly,
to-
my lord, for a moment, my lord, kindly come to page 67. This is the original advertisement. Pursuant to this advertisement, my lord, he was appointed in the district deputy commissioner's office, my lord, at Dibrugarh. My lord, that is type copy at page, my lord,
Okay.
65, my lord. 65. My lord, 65, kindly come to page 65. Para 3, my lord, essential qualification. Bachelor's degree in science or with statistics, geography, environmental science or geology. Geology as subject or diploma in civil engineering or architecture from a recognized university institution. As per this advertisement, my lord, he was appointed, my lord, kindly come to page 64. This is his experience certificate, my lord. He has experience more than 3 years, my lord, 5 years experience. He uploaded this certificate also. And only these grounds, my lord, my lord, that we do not have any, my lord, work experience relevant to our zoology, sir. I have, my lord. I uploaded it, my lord. Kindly see, my lord, 64 page. And as per the advertisement, my lord, page 65. Pursuant to this advertisement, my lord, he was appointed, my lord. Here clearly mentioned, my lord, zoology background from recognized university or, my lord, any institution. So, my lord, at this stage, my lord, my humble submission, my lord, at least 2 posts, my lord, shall not be, my lord, appointed. Both the petitioners have, my lord, much experience, my lord, in the relevant work experience. I have submitted, my lord. The writ petition also, my lord, I submitted online of website of the, my lord, appointing authority. And they have, my lord, they got, my lord, more than cut-off mark. One, he got, my lord, 77, 78, my lord. Cut-off mark
number-
was 70, my lord.
That number two, petition number two, he was a professor. He doesn't have.
Professor, my lord,
experience
he
with
has also, my lord, kindly come to page, my lord. 76, my lord. 76, my lord. Now, relevant to geology, my lord. He has the work experience certificate is, my lord, related to geology subject. They are both are, my lord, geology background, MSc in geology.
So what is your prayer? What do you want that?
My
What is
lord,
your interim? What?
interim, my lord, at this stage, my lord, two posts, my lord, shall not be, my lord, appointed. At least two posts shall be vacant.
What about the other person who four have been appointed? There are six.
No, already appointment is not yet made. Only the merit list has published the merit list, my lord.
We have four posts.
Appointment is going to take place in a day or two because tomorrow there is a verification. And number one, and now Lordship will kindly come to page 76. How he is trying to mislead this honorable court.
I am not misleading. No, these are the.
Don't give commentary. I am making my submission to the honorable court. I do not want to hear commentary. So Lordship will kindly see page 76. What is this office? Office of the Principal, Dibru College. This is to certify that Devesh Nath was working in this institution as lecturer in the Department of Geology from so-and-so to so-and-so date. As a teacher, he was very regular and sincere. We are not after teachers. We do not want faculty members. We need people at the drilling site. The basic thing, work site, who are accustomed with the practical experience. We do not need teacher. He has confused everything.
No, my lord, page 79, here is clearly mentioned, my lord. This is also an.
So next, the previous page,
experience
the
certificate.
deputy commissioner's document. What was document did he was saying?
79. Working with us
You
as a.
finished, kindly finish, then I will
No,
start.
I'm
Don't interrupt when I am submitting.
back you submit.
Now, Lordship will kindly see ANI we are considering, page 79. That will not fit
That
3
you
years.
state, that you have already stated.
Yes.
ANI you are
Now, deputy commissioner's document also he has said regarding the first. Because he has very categorically stated in paragraph 10 of his pleadings. What I am submitting, it is not our story. The story which he has projected before this honorable court, that I am projecting. Again, let us come back to page 10. Page 10 regarding petitioner number 1. Page 1, Director General of Hydrocarbon, what he was doing, he was obtaining statutory clearance certificate. That means license, etc. So he has no site visit or no site work. ANI we are taking 22/9/2000.
Yes.
That we have taken.
Yes.
Third is Assam Disaster Management. I think that is the deputy commissioner page.
Yes, that is the
Page
certificate you are
66. Let
referring
us
to.
come to page 66 now.
57. Original.
So deputy commissioner, yes. Here, applications are invited from interested candidate walk-in interview for the post of field officer, disaster management in all revenue circles of Dibrugarh on purely contractual basis from 10th January 2017 at the venue so and so. Now, post titles, serial number 1, field officer disaster management for revenue circle, total number of posts 7, essential qualification BSc in science with statistics, geography, environmental or geology. Then next page, Lordship will kindly come. Duty station, he will be stationed in the revenue circle office. So he will be in the office work and work under the direct control and supervision of the circle officer, who will be the authority to sanction leave and reporting officer, duration of the contract.
This is in the DC office only.
This is office.
My lord, the geology, my lord.
How can that be having relevant experience at the drilling site?
That is what I am saying.
That is Mr. Lordship, absolutely correct. Absolutely, Lordship has read the whole thing in the right perspective. I am trying to never mislead this court.
My lord,
When
I'm not
we want-
misleading the
and-
court, my lord. This is face
No,
of the
it's
record,
okay,
my
it's
lord.
okay,
This is face of the record, my lord. My lord, essential
cannot-
qualification meaning by my lord.
That you have suggested something, no?
I suggested that notice may be issued. Any appointment made in person to the advertisement should be subject to final outcome of this. Suppose after 1 year he wins the case.
That is better.
That is better. I'm
Yes, my
protecting, I'm trying to help him.
Yeah,
My lord,
he's
I am
trying to
obliged to
help you.
that, my lord. But my lord, essential qualification meaning by my lord.
That will be
Here
a part of
clearly
hearing.
mentioned, my lord. Face of the record, my lord. It is
Really?
geologist.
3 years.
They are
experience
the
in the
geology
relevant
background,
field.
my lord.
Relevant
Where
will
I,
be
my lord, am
his
misleading the
work
court.
scope,
Maybe you have a point. We will pass that order that.
subject to final outcome.
Yes. Any appointment.
That is right, my lord. But
That is
my
right.
lord,
Pursuant to this,
my lord,
will be
the essential qualification.
such a good
My
protection
respected, my lord,
getting-
AG,
I would-
my lord,
that
saying that
some
I am
said-
suppressing, my lord.
others
Where
said
I am suppressing, my lord, the face of the record, it says,
No,
my
no,
lord,
no.
essential qualification, my lord, from zoology
It's
background.
okay that paragraph 45, 1, 2, you have read. The third is relevant. That is what he's saying.
3 years experience in the relevant field. And field means
I
the
have
drilling
5
site.
years, sir. I have 5 years, sir.
Overall 5 years experience, but not in the relevant field.
One is a professor and I have another ground. Two persons have different causes of action.
My lord,
They have amalgamated both together. That repetition is also not maintainable.
another point, my lord, if I do not have the experience, my lord, in the relevant field, why we are called for, my lord, CBP?
You have a point. I'm saying you have a point. So we'll give you some sort of protection. Hard learned counsel, Mr. S.A. Ahmed,
Yes, ma'am.
for the petitioners, দুজন petitioner নামকেইটা লিখি দিবা, ৰূপম সন্দিকৈ, দেৱাশিষ নাথ,
Two petitioners.
who have filed this application under section number. Second. Under Article 226 of the Constitution of India for issuance of a writ in the nature of mandamus or any other appropriate writ. Against the notification,
Advertisement, my lord. As per
advertisement number,
advertisement dated 30/12/2023.
advertisement dated 30/12/2023, being advertisement number HR82 stroke RECW WP REC-WP-B stroke 2023-81.
My lord, the petitioners applied for the post of, my lord, at serial number 22 at page 45.
Heard Mr. D. Circuit, heard learned senior. No, you will come as
Senior-
standing counsel.
Senior
no?
standing, senior advocate.
Learned senior advocate, not standing counsel,
No, this is Oil India. I'm appearing for Oil India. Limited.
All India. Learned senior advocate, appearing for.
Respondent number
While
two,
respondent number
three,
2, 3,
4 and 5.
4 and 5. The petitioners have, through the aforementioned advertisement, the petitioners have applied for the post of
Serial number 2 BGE.
45 page, my lord. At serial number
BGE
BGU
12023.
12023.
12023. And they are agreed by the result.
Yes.
Result at which page?
Is, my lord, at page 106, my lord. 107, my lord.
105. Their result is at 105.
That is merit list. Merit list, my lord, 105.
But the final result of the aforementioned post dated 6/6/2025, full stop. The petitioners were not selected as they were, as the observation was that they had no post-qualification relevant work experience. As the observation was that they had no post-qualification relevant work experience. It is submitted on behalf of the petitioners that the petitioners have successfully
Pass the CBT, my lord. Computer-based test.
passed the CBT test, and the petitioners have obtained marks much higher than the cutoff mark, i.e. Petitioner number 1 is equal to 77, petitioner number 2 is equal to 78 out of 70. Furthermore, the petitioners have sufficient experience, which has been mentioned in
Paragraph 10.
para 10 of the petition. It is submitted that the petitioner number 1 has more than 5 years of experience, whereas the petitioner number 2 has 3 years of experience. The learned counsel for the respondent oil has raised objection against the petitioner's prayer for holding 2 posts, as the petitioner, as the petitioners have been, petitioner's results have been correctly declared by the oil. The petitioners do not have really sufficient experience in the relevant field, which pertains to drilling in the oil field. The petitioner
4 years period.
For 3
Oil
years.
field is not
The
mentioned,
petitioner
madam.
has
LOG. That is my submission.
for 3 years. The petitioner has much less. The petitioner's experience is much less than 3 years, up to
Much below 3 years, and their other experience
below
of
3
working
years.
is relating to administrative service.
and teaching.
Teaching.
Much below 3 years, and the other work experience is related to administration and teaching.
Teaching.
And disaster management. Administration, disaster management, and teaching, which does not fall within the criteria of the advertisement. After considering the submissions, it is further submitted on behalf of the petitioner that as the petitioners were selected and qualified for CBT, they are deserving candidates, lest they would not have been selected for CBT. Full stop. I have considered the submissions at the bar with circumspection.
One more submission, that they have not made the necessary parties included in the petition. The selected candidates were not included.
It's true, but he's not willing to.
No, he's not, that is my submission.
It is.
As a well, the represent not
maintainable.
maintainable.
Submission or DDR. It is.
I raised the issue of maintainability, as necessary parties were not included.
It is further to Eketor submission of DDBA. It is further submitted that it is further submitted on behalf of the respondent that the petitioner, but that this petition is not maintainable, as the adversely affected parties ought to have been impleaded as necessary parties. Full stop. I have considered the submissions at the bar with circumspection. Tapa continue Korea. at the juncture, the respondents, the selection, it is hereby directed that the selection process will. What was your suggestion?
Now, only the police
was a-
verification part is there. Selection is over.
Okay. Yeah.
Before
That is,
joining, we
yeah.
have to do their health test and police
No,
verification.
you have suggested
yes.
measure. What
That
was it?
Lordship may be pleased to issue notice. However, it is made clear that the selection process undertaken by oil shall depend upon
Selection process undertaken by oil,
subject to final outcome of this report.
shall depend upon subject to final outcome of this petition. It will be yeah. This is a good.
Yeah.
This is a good. measure.
Case is alive.
Yes.
Case is alive. If we can satisfy.
Issue notice.
Only the appointment shall be made
Respondent number
subject to
6. No,
outcome of
only
the-
one next respondent.
Two posts. He
No,
wants
how many
to.
respondents?
Uh,
That I had mentioned.
Yes.
I have dictated.
There are 5 respondents.
You are one.
Five, my lord.
One.
I am for 2 to 5. One is central government. So central government, SGSC will take notice. My friend will take notice.
Okay. The council is beginning of notice has been accepted by Learned Senior Council on behalf of oil, and thus no further notice is required to be issued. Our effect Miss A. Pugon, Senior Government Advocate. CGC. Miss A. Pugon, Learned CG is present for respondent number 1. Respondent number 1. And a notice has been accepted on behalf of notice number respondent number 1, and thus no further notice is required to be issued.
A date may be
List
given
after.
for his
List after.
my lord, as per convention.
4 weeks.
List after 4 weeks.
Deeply.
Obliging.
Your Lordship, before starting, I have to say, submit something, Your Lordship. Your Lordship may kindly peruse the last order passed by the Honorable Mr. Justice Sumon Chiam, Your Lordship, on 25/6/2025, Your Lordship.
Yes.
Yes, so by order, they listed this matter. Twice the matter has been called, but they did not appear, Your Lordship.
What happened on that day, my lord?
And
Actually,
let me finish. Then again, this matter has been fixed after vacation, Your Lordship. That this already order is there, Your Lordship. Again, by order, he has made listed this matter today, Your Lordship. How can it be possible, Your Lordship?
may I clarify, my lord? My lord, what happened, my lord? Initially, I made a mention for listing this matter because there is some urgency there, my lord, for listing on last Thursday, my lord. But my lord, unfortunately, it was listed on Wednesday, my lord, and in the supplementary list as by order, my lord, and somehow it was, my lord, escaped from my eyes, my lord. Subsequently, on the next day, on Friday, on Thursday itself, my lord, on the same court, my lord, before the same court, I made a mention, my lord, and apologize for my mistake and for taking up the matter, my lord. On my lord, last day or my lord, in 30, my lord, because my lord, there is an order for my lord recovery from my salary, my lord. And considering the urgency, my lord, the honorable court, my lord, has permitted to list.
What from the salary?
Here, my lord, what happened, my lord, in this case, my lord, pursuant to a, my lord, recommendation of my Central Pay Commission, risks and hardship allowances were sanctioned to the CRPF personnel who were, my lord, deployed in, my lord, specified area, my lord. And thereafter, my lord, by another notification, my lord, the said allowances were sanctioned, my lord. And now, my lord, on 28/2025, my lord, this is the, my lord, impugn communication, my lord. By this communication, my lord, and there is a order has been passed to, my lord, stop the, my lord, risks and hardship allowances, and also, my lord, to initiate the process of recovery, my lord. And similarly situated person has
Recovered.
Lordship, my
To
lord,
be recovered. When it is proposed to be recovered?
to the person similar to me, my lord. This impugn communication is there, my lord, and this impugn communication has already been challenged in another writ petition, my lord. And this honorable court, my lord, while my lord issued notice, my lord,
was my lord granted interim my lord to my lord stop the my lord recovery.
This case was fixed for summer vacation. Why did it come here?
Lordship, my lord, because there is there is a order for recovery, my lord. If my lord similar order is not passed in this case, my lord, then my lord recovery process will be initiated, my lord. From the same battalion, my lord, another person has my lord.
What to say, Lordship? This is not a vacation court matter, your lordship. That's what I can say.
Yes, yes, definitely.
No, lordship, my lord. Otherwise, my lord, in the next month, my lord, from the salary, my lord, my our recovery can be made, my lord, from our salary, my lord. So, my lord, since my lord, another matters are pending, my lord. Similar, I want my lord similar order, my lord. From the same battalion, my lord, another person has approached, my lord. Squarely same, my lord. Similar order, this is already case pending as a packet.
Your lordship, then notice can go at this stage. Notice can go.
And my lord, till then, my lord, similar.
No, your
similar
lord,
case.
not today.
Otherwise,
your
my lord, recovery will be made, my lord. Those who were already, my lord, approached, my lord, their recovery is stopped, my lord, and my lord.
They are similar.
Similar, I am praying for similar order, my lord.
Have you gone to this order?
I have
No,
like
just
this.
today I have received your.
Exactly same, my lord. Same communication, my lord. From the same battalion, my lord.
Same battalion.
Some battalion.
Same.
Same, my lord. Same CRP person, my lord.
Two 203 petitioners.
Here, my lord. And in other case, my lord, there was 88 probably, my lord. In earlier case, my lord.
Where's on which page is the prayer? Page
Prayer.
50.
Lordship, my lord. Page 56, my lord. Page, start from page 55, my lord. And interim prayer is, my lord, page 56, my lord.
Impugn communication dated. This is the communication, no?
That, yes, my lord.
To withdraw the risk allowance.
Lordship, my lord. 28/4/2025, my lord.
Let me check. At which page?
In Pregab, page 56, my lord, my interim prayer, my lord.
No, 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 no.
Communication,
That communication at which page?
page 99, my lord. Annexure F. It's a type copy, my lord, and vernacular is also there, my lord. Vernacular is at page 102, my lord.
Poem dated, this is 28 April. This is 31 April. 31,
Okay.
31 July.
Oh, Lordship, my lord.
Not same.
Yes. Yes, your lord.
No, it's my lord.
Okay, yes, yes.
Yes, my
Yes, yes, same, same.
Same, my lord. Last prayer, having regard to the fact and circumstances of the case, it is entirely as interim measure. It is hereby provided that there shall be no recovery of RSA amount paid to the petitioner in term of impugn OM dated 24/8/2025. my lord.
In fact, my another case is also pending, my lord, out of same communication with.
It will read. Okay, then. Similar.
Similar.
Same.
Okay.
Third learned
Okay, Bro.
for the petitioners duta asate who have filed this application who have filed this application under Article 226 of the Constitution of India with prayer to issue a writ of নালাগে prayer নালাগে
Number to listen, number to see,
for the writ petitioners লিখি দিয়া article নালাগে for the writ petitioners তাৰপিছতে এইটো হেৰি থাৰ্ড মিছ কেপ ফৰ learned CGC for which one respondent? All respondents for the respondents. তাৰপিছত এইটো হেৰি কৰিবা এটা মোৰ কপি এটা দিছো WPC 2866/2025 নামবোৰ হেৰি নিলিখিবা তুমি পেৰাগ্ৰাফ গোটেইকেইটা লিখি দিবা পেৰাগ্ৰাফ 1 2 কাউণ্ট কৰি ল'বা দেই ইয়াত পেৰাগ্ৰাফ দিয়া নাই খালি এডভকেটৰ নাম নিলিখিবা 1 or 2 learned counsel learned counsel Mr. H. Borua
K. Borua.
K. Borua বাকিখিনি লিখি দিবা 3 পেৰাগ্ৰাফ বাকিখিনি একে খালি ৰিট পেটিশন নাম্বাৰটো ইয়াত WPC 2866 of 2025 লিখি দিবা ইয়াতে 168 লিখা আছে তো বাকি কি আছে পেৰাগ্ৰাফ 1 2 3 4 4 লিখিবা খালি নাম হেৰি CGC নাম কে কোন লিখিবা তাৰপিছতে পেৰাগ্ৰাফ 1 2 3 4 5 6 নামখিনি খালি চাবা দেই 7 8 Same OM, na?
Same, man.
28/4/2025?
Same OM.
Same OM?
Same OM.
ঠিক আছে কন্টিনিউ কৰিবা 1 2 8 So we'll list it with the other matters.
Lordship, man. Take together.
Okay.
Notice has not been issued. Today it has come for the first time.
Notice may go, man. And serve
Yes,
extra
yes. Notice
Extra copies, extra copies.
extra copies লিখি দিবা নোটিছৰ লগত extra copies লিখি দিবা আৰু এইটোৰ লগত 168 of 2025 list this matter along with 168 of 2025 and WPC 2866 of 2025 all these matters will be together.
Lordship. Civil and.
Obliging.
Obliging.
এইটো petition টো ইয়াতে আছে হা WPC 2866.
May please your lordship.
Yes, yes.
Well, this is against an order of transfer.
Oh.
That order your lordship will find at page 13. The petitioner is a registrar of Labor Code Guwahati. By the impleadment order, she has been transferred, thought to be transferred to Dibrugarh. Her case is that the private respondent, respondent number 3, on his request, my lord, this order of transfer was issued. And her further case is that she is a single mother with only one daughter whose education she has to take care of.
There was an order earlier.
In fact, my lord, there was an order and my lord, it was directed that they'll produce the records to show, my lord, whether it was in the public interest or it was in the request of the respondent number 3. Records were directed to be produced.
Order dated 25/6/2025. We are directed to collect a record from the authority concerned.
Yes.
Same day, we have written a letter to the authority
Yes.
concerned, but yet to be received the record.
Yes, yes.
That's why it may be listed after vacation.
First day after vacation.
Yes, well, let it come out of vacation, but till that time, my lord, the status quo has to be protected, my lord. But there was a protection by that last order, your lordship.
Lordship.
Yes, yes. It will be extended. No coercive action will be extended. Had vacation official date is the DD 21st of July. All right.
First, we have to check out the record, Lordship.
That was the direction.
Lordship. Just after the vacation, Lordship, it may be.
Yes, after the vacation.
Till then,
21st July.
no stay should be granted, Lordship.
No, no, no. We'll extend the stay. It has already been granted. We cannot vacate the stay.
Lordship.
Heard learned senior counsel Mr. M.K. Chaudhary for the
Petition.
writ petitioner and
I am T.R. Gogoi, Lordship.
T.R. Gogoi for
Yes. All the
One and
2
2.
and 3.
1 and 2. 3 is
One
not
and
government.
1 and 2, sorry.
1 and 2
1 and 2.
government.
employee, government employee.
Respondent number 3 is a government employee. That notice has to go, my lord, to him.
Okay, okay.
I am 1 and 2, Lordship.
You will be government advocate, no?
Lordship.
T. Gogoi.
T.R. Gogoi, Lordship.
T.R. Gogoi, learned senior government advocate.
Junior government.
Learned government advocate for respondent number 1 and 2. Full stop. Where was the order? Okay.
25/6.
25/6.
Record as call for is not received. It is submitted by the learned government advocate that records will be placed on the next date fixed. List the matter of 21st July. Meanwhile, the interim order shall remain in force till the next date of listing.
Hello.
Obliged. Item 40.
May I please? My lord, petitioner applied for my lord Central Armed Police Process, my lord, in 2024, my lord. My lord, by mistake, my lord, he applied in economic weaker section as well as in OBC section, OBC category. But my lord, at that relevant of time, my lord, the OBC certificate was not with him, my lord. He got later on, my lord. So, my lord, there is, my lord, instruction and rule, my lord, that if a person apply for multiple time, my lord, he will be debarred from, my lord, for 3 years from applying, my lord. In fact, my lord, my submission is this, my lord. My lord, remain absent in, my lord, OBC category because, my lord, the 3-layer examination is there. First is, my lord, computer-based examination. Second is physical standard test. And third is physical eligibility test. And why the petitioner, my lord, realized that yet he committed a mistake, then, my lord, he abstained from, my lord, appearing in OBC category. So, my lord, my submission that he not appear, my lord, because, my lord, he remain absent after, my lord, computer-based examination. Thereafter, my lord, in 2025 examination, my lord, I appear, my lord, I got, my lord, sufficient marks, my lord, and computer-based examination, my lord, I successful, my lord. But my lord, my apprehension is this, my lord. Since 3 years, my lord, ban is, my lord, against me, in the coming days, my lord, very soon, my lord, physical standard test and physical eligibility test is going to be held, my lord. So my only submission is this, my lord, my lord. I may be allow, my lord, participate in physical test examination and physical eligibility test, my lord. That much, my lord, prayer in the interim, my lord.
Your lordship, today notice may go, your lordship. Already he has filed one more,
No, that is right.
and petition is pending regarding same matter, your lordship. So that's why due to apprehension only he has filed this. Already he has been allowed to sit in the written test. Just few days back only that examination is over. So till now the PST test and that other test that has not been finalized. Your lordship, that is why today notice may go, and
My
detailed
lord,
instruction I will bring after vacation. Your
if my lord, I shall not be allowed to participate in physical test or physical
Already his name is
eligibility
there,
test,
your lordship, in the
then my
last
lord, my petition will be infructuous. There will be no meaning of filing this petition. And my
So
lord,
what
my,
kind of protection do you want?
not protection, my lord. I may be allowed to participate in the physical standard test that is
Already
running.
He's saying that you are already
your
being
name
allowed.
is there, your lordship, in the last page number 129 of the petition, your lordship.
Page number?
129.
Yes, 129, yes, computer examination, my lord.
222-843. His name is there.
Yes, right.
Because of that only he has completed his written test, your lordship.
My lord,
Angkar Chauhan.
Yes, next step is for PST and
my lord, examination, my lord, 225, my lord, this is the subsequent examination. I, my lord, successful. My lord, now physical test and physical eligibility and physical standard. The
step by step is going on, your
test, my
lordship.
lord,
That's why, since he has qualified, then next step.
So it's okay, you appear. She's
yes,
stating
that's much, my lord.
No, today your lordship notice may go.
My lord, I'm not, my lord,
Date
praying
has
for
not been
appointment
finalized
or
yet.
any other such relief,
Only
my
few
lord.
days
Just, my
back.
lord, I'm praying for, my lord, I may be allowed to appear because my apprehension
That
is
has
there,
not
my
been
lord.
said today, your lordship. Already he has
My
been allowed to
apprehension,
sit in
my
the
apprehension
written
is
test.
that, my lord,
And next step is for PST. And
Third learned counsel Mr. S. Chauhan
my lord,
for the petitioner Angkar Chauhan, who has filed this writ petition to enable him to appear, so that he will be here, so that he may be allowed to appear for the physical
test examination and physical eligibility examination.
and the physical eligibility examination
2025, 2025.
proposed to be held on
My lord, if the, just my lord, now, my lord, it will be started. It will be start, my lord.
proposed to be held on
Very
this
soon,
month.
very soon.
Huh?
Date is not
date
given,
has
my
not
lord.
been finalized. That's why today I
Yes,
said
date
your
is
lordship
not
today
given, but
notice
it
may
will
go
be
already.
Being
start.
held in this month. It is submitted that the petitioner has cleared what exam? What exam he has? Written test.
My lord, I successful in computer-based
The
examination.
petitioner has cleared his CBT test for the post of what?
My lord, Central Armed Police Force.
For the post of constable in the Central Armed Police Force.
Yes.
Learned government, learned CGC, Miss K. Pukan, has submitted that the date to hold the physical test examination and physical eligibility test
Well,
have not been finalized. The petitioner has already been allowed to sit for the written test and the CBT examination, which he has already cleared. So at this juncture, no interim order may be passed. Full stop. Earlier, earlier in what exam? For the same exam?
my lord, PGT I have not clear, my lord. Only computer-based examination I have cleared.
No. Earlier, from which
Earlier, my
examination he was
lord,
banned?
for appearing, my lord, applying in two category, I have been banned, my lord.
Earlier in which year?
In 2024 examination.
For the same?
Yes,
Constable
same
post.
constable, yes.
The petitioner is apprehending that he may not be allowed to
Participate.
appear for the PTE and PET.
Yes.
PTE and PET?
PST and PET.
PET and PST exam, PS uh,
2025.
exam nalage, as earlier, 3 years back.
Yes.
When, which year? He was banned?
Because he, some ban upon him, your lordship, some ban has.
Earlier in which year he was banned?
2024 examination I did.
Earlier in the year 2024, he was banned from appearing on any examinations as the petitioner had
Yes.
had filled up application forms to appear as OBC category candidate and EWS, EBC, economically backward, EBC category candidate for the same examination, which is debarred by the authority, full stop.
For 3 years.
Which is debarred by the authority for 3 years.
3 years, yes.
So now what type of protection do you want?
Well, not protection, my lord. Just, my lord, I praying for my lord, allowing me to participate in the PhD and PET.
Automatically he will be called, your lordship, if he has, if he will clear the written test.
It is further submitted that it is for next prayer, Rika. On the other hand, it is submitted by the learned CGC that the petitioner will automatically be called for to appear for
PST and PET
PST and PET
examination.
Thus, at this stage, a notice of motion may be issued to the other respondents, being respondent number 2, 3, 4.
All for all respondents.
For all the respondents, list the matter after. List. Do you want a date?
My lord, my learned friend said the automatic call, my lord.
Yes,
Then,
yes.
my lord, her statement will be recorded. Because, my lord,
If
I
he
have
qualify written test, he
because,
will
my lord,
call.
I have apprehension because impugn order is there, page 68, my lord. Bar is there.
List
So,
the
my
matter
lord,
on
my apprehension that I will not be called.
30 July.
Oblige.
My
Or
lord,
you want an earlier date?
before date, my lord, on 16, my lord.
16?
16.
Okay, 16 days.
18.
16 days, yeah.
Oblige.
Right, Vijay. On the same day, 3 orders are passed regarding promotion and posting. If your lordship kindly comes to page 15. This is an order, page 15, by which assistant matron, the petitioner is the assistant matron, they were promoted as matrons. Page 15, your lordship will see, this is the first order. In pursuance of the government approval by letter number circumstances dated 21/6/2025, and as per the recommendation of the promotion committee, the subject to reversion without notice and without assigning any reason thereof, and until further order, the following incumbents presently holding the post of assistant matron, assistant nursing superintendent, etc., are temporarily promoted. Now, my lord, the name of the petitioner appears as serial number 6. Khadeja Khatun. She was assistant matron. In fact, my lord, the in charge matron of LGB Chase Hospital, Guwahati. And she has been posted at LGB Chase Hospital, Guwahati in a resultant vacancy of Gunokanto Gohai. Then your lordship will come to the next page.
Yes.
Page 16, my lord, the continuation of that order. Serial number 11, your lordship will find Kola Deka. Serial number 11.
Yes, yes.
She is in Chandrapur, MH Kamrup, and my lord, she has been posted at SDCH Bukakhat Golaghat. And your lordship will also kindly take notice of the fact that my lord, serial number 13, Gunokanto Gohai. He is, my lord, matron of LGB Chase Hospital, Kamrup Metro, and he is retiring today. So, my lord, on his retirement, I have to join in Guwahati Chase Hospital, and she has to go, private respondent has to go to my lord Golaghat from Chandrapur. Then, my lord, on the same date, immediately thereafter, another order has been issued that your lordship will find at page 20. This transfer and posting order has been cancelled. Page 20. promotion order of the post of assistant matron, etc., dated 25/6/25 is hereby cancelled.
Okay.
Then thereafter, my lord, serially, the next order at page 21, the another order has been issued. Here, my lord, the petitioner has been sought to be posted on promotion at Nalbari, serial number 6 again, my lord. And the private respondent, she has been posted at my lord, my place. Now, my lord, my submission before lordship is this. Firstly, my lord, they have already issued a, my lord, transfer, promotion and transfer order on the basis of government approval. There has to be some reason why it has to be it has been cancelled. And only change that is made, my lord, in respect of the 45 persons who transferred and posted, this is regarding me only. So there has to be some, my lord, I have stated in the on a oath that there has been some political influence. And therefore, my prayer before lordship, my lord, she has filed an application earlier saying that I have got the arthritis problem, is difficulty in walking, I have to take treatment. Therefore, I may kindly be posted at Guwahati. And that was considered perhaps, my lord, and she was posted. Then, my lord, all on a sudden, for whatever reason, my lord, this has been, my lord, changed. She has been sought to be transferred to, and it is only to accommodate the, my lord, private respondent. So my prayer before lordship is that, my lord, let them produce the records and show, my lord, why this order has been cancelled on the same day, which was approved by the government, and only, why only my posting has been changed. In my lord, respect of the 45 persons, there is no change as such, except, my lord, 1 or 2. And, my lord, this has been sought to be, my lord, posted.
Lordship, here, one statement, Lordship, it's not only regarding the petitioner, Lordship, there have been more changes also. Lordship, serial number, if Lordship sees, serial number 12 only, Lordship. Here, serial number 12, 25, 26, 27, there have been a lot of changes, Lordship. Here, and this, as per my instruction that I have received, Lordship, it has been only because of the smooth functioning of the administrative side. That is why it has been done. And it has not only for the petitioner, Lordship. Lordship, I can, from this
One
list,
day, 3 transfers.
no, not
One day, 3 notifications.
no, Lordship,
Same
one
day.
of the notification is for cancellation of the previous one. So the third one was the final list, Lordship. And here, Lordship, from what I have received instruction telephonically, that the petitioner was given an option in another zone also, which the petitioner did not accept, Lordship. So, Lordship, some time may be granted. The case of the petitioner, it was also, as per my instructions, the authorities have said, you join the because the person who has been accommodated in front of this private respondent, Lordship, as per my instructions, she is the senior most. So maybe keeping something in mind that that is why they have given her the post.
Suvala Dega.
Suvala Dega, the private respondent in this. So, Lordship, here I can produce the record, Lordship. Lordship may not pass any interim order today, Lordship. This is coming for the first time. Let us obtain the instruction. And immediately after vacation or on 10th, Lordship, we can come up and Lordship may hear the matter. It is a transfer matter, and it's not just the petitioner, Lordship. I can hear from the list only, I can show there are like 5-6 people who have been transferred. It is only for the smooth, effective.
My lord, if he has completed, my lord. In the, my lord, normally in transfer orders, your lordship is very reluctant to, my lord, interfere. That, my lord, that is the law. Except that, my lord, if your lordship finds that it is not in the public interest, then your lordship will interfere. Now, my lord, perhaps my learned friend has not been properly instructed. The petitioner is the senior, much senior, my lord, if I may place this. She is the senior most, my lord. In the gradation, this is a gradation list, my lord. So, my lord, that is not
Maybe
the ground.
something relating to the age.
My lord.
Yes,
Maybe
Lordship,
something
that I
relating
don't
to
know,
the
Lordship, because this is coming here for the first time. And here,
that's why my prayer is, my lord, let them produce the records immediately after the vacation, my lord. Until that time, without interfering with the others, my lord. So far as the private respondent and me is concerned, my lord, status quo be maintained, my lord, till that day.
Where is she posted now?
My lord, I am posted in Nalbari, and the private respondent is posted at.
No. At now, what post is she holding now?
She is holding, my lord, the post
Matron.
of assistant matron.
Assistant matron, you want to stay here now?
Yes, ma'am.
As assistant matron,
No, my
without
lord.
being transferred.
The promotion, my lord, my promotion was and posting was given as, my lord, matron in, my lord, LGB hospital in Guwahati itself, my lord.
You want to be in Guwahati now?
Yes, my lord.
That is
As
because of her ailments, my lord. Because
As
she
matron.
cannot my lord, properly walk. and she has to get, my lord, regular treatment.
Okay, why the decision has been taken?
Now, my lord, the decision, my lord, the question is, my lord, why do you change the decision all of a sudden, my lord, then the same day when the approval was already given by the government that has been reflected in the first order? Therefore, my lord, the records will only reveal, my lord. I have alleged, my lord, malafide in my lord, the petition. If your lordship kindly comes, my lord, there must be political
No,
interference.
but
my
you
lord.
see, maybe,
That is apprehension.
maybe, but he's asking for time to produce the records.
So in the
Whether
meantime,
the promotion was for public interest.
yes, my lord, that is the only
Let's-
part your
let's-
lordship will examine.
Let's find out if
Your
it's
lordship,
for
because-
public.
Yes, my lord, your lordship will find out, but in the meantime, my lord, if the transfer order is carried out, my lord, everything goes.
Your Lordship, I'm also not aware if the private respondent has joined the posting or not. Lordship.
No, they cannot join because that is very clear. Because the person who is holding the post of matron here in Guwahati, he's resigned today only. So they cannot join. That is very clear, my lord.
Maybe, Lordship, yes, Lordship, that is why I'm saying, Lordship not may consider interim pay on the next date, Lordship. Let us produce and why.
On the next day, on the
No,
next
no, on the next day, your lordship will consider, but till
Yes,
that time,
lordship,
my
but-
lord, if the transfer is affected, my petition becomes infructuous. Let my lord, the petitioner and the private respondent maintain status quo till the next day, my lord, let him produce the records. With the records, your lordship is, my lord, satisfied that there is public interest in this.
Status quo
Not
may
a-
be maintained.
Yeah, status quo.
Status
quo.
Only status quo.
Only status.
Status quo in respect of the petitioner and the my lord, private respondent. Because my lord, order pertains to 45 persons. It will not affect. So
Yes,
that may be
yes.
clarified.
Yes. Third learner, senior counsel, Mr. M.K. Chaudhary, for the petitioner. For the writ petitioner, Khadija Khatun, who is aggrieved by the order of transfer
And posting, you know,
and
transfer and
posting at Nalbari, while order dated
Order dated 25/6/25
25/6/25.
at page 20. Annexure 5, page 20.
Marked as annexure 5 of the petition. No. Annexure 6, I think.
I'm sorry, madam. Annexure 6, page 21.
Marked as annexure 6 of the petition.
Last 21. Page 21. Annexure 6.
25/6/2025. It is submitted that on the same day, an order was passed transferring and promoting the petitioner to as matron at Guwahati.
My lord.
Thereafter, on the same day, while annexure number 5, this order,
Was cancelled.
order number, order number NS/EMP/25/ hyphen 111/2000/278 was cancelled, and the petitioner's place of posting was changed from Guwahati to Nalbari. The petitioner is it is submitted that if this order transferring the petitioner to Nalbari is not stayed, the petitioner will be highly prejudiced, as the petitioner is suffering from spondylitis,
My lord, arthritis, my lord.
from
Osteoarthritis.
and the petitioner is the senior most
Assistant matron.
assistant matron of the institution. Full stop. Heard, Mr.
A. Chalia. A. Solia, Lordship.
A. Chalia, learned
For the health department, Lordship.
on government council,
Standing council, health department, Lordship.
learned standing council health department, who has raised serious objections stating that the respondent, Kuala, she's a respondent, no?
Yes, my lord.
The private respondent, Kuala Deka, is Deka's promotion was considering her age and seniority. The learned council has submitted for time to obtain what did you want to obtain? Records. Obtain records relating to the cause of transfer, and if the transfer was effected on public, what is this called?
Whatever it is in the public interest.
Oh, transfer was effected on public interest. Full stop. records may be obtained. List the matter on.
Lordship will give us a earlier date, Lordship, so that because status quo is already
18 July. Petitioner to take steps to issue notice to the other respondents.
private.
To the other respondents returnable on.
Response number 5, my lord. I'll
Response
take
number
step.
5 returnable on 18 July. Till then, status quo to be maintained as of today.
Status quo in respect of the petitioner and the private respondent.
Petitioner, Harry
And the
Khureza
respondent
Begum,
number 5.
Khureza Khatun, and respondent
Number 5.
Kuala Deka to be maintained as of today.
Lordship, one Lordship observation. Lordship, I have also stated that the petitioner is not the only one whose transfer order has been changed. Why
And it doesn't cover.
there are other yes.
It is further submitted on behalf of the respondent that the respondent health. What? Health department.
The petitioner is not the only person whose post has been changed. Why the orders? Yes.
Petitioner is Lihilana.
Highly obliged.
Item number 60 for admission.
My lord, the present FAO is against the order dated 13/6/2025, passed by the learned civil judge, senior division number 2, whereby the ad interim injunction which was granted,
Just a moment. You have come against the order of injunction.
rejection, by which
Rejection.
the
Just a moment. Just speak. This is for admission, isn't it?
so first appeal is a matter of right. Along with it, I file an IA. So again, praying for an injunction, otherwise the nature and character of the suit will change. So I am praying that, Your Honor, the opposite parties may be directed to maintain status quo as on today.
Okay.
Only prayer is there.
I'm appearing for the opposite party. Today we were supposed to file the caveat, but we came to know about the appeal, listing of the appeal. So we have filed Vokalavnama today. Only, Your Lordship, I am opposing his prayer for status quo because he has no prima facie right. And that is the finding of the trial court, and he has no possession also. That is an admitted position.
So those findings we have impugned because apparently he is not disputing my title.
Let us let him file the objection.
Till then, Your Honor, status quo may be directed to maintain because he is all prepared to construct over the property.
It will be
And-
removed if you have a good case.
No, Your Honor, it's not about removing, Your Honor. If Your Honor peruses the photograph, here the case is that if they construct, my right to
No,
light.
no, I'll give you a very short date. Very short date. He will only file this objection.
My lord, just one thing. If Your Honor, in IA, page 69, if Your Honor takes up the photograph, the nature of construction. Because otherwise the law is settled. If any construction is there, that will be subject to outcome of the suit. But here, if they construct, Your Honor, there another problem arises. Page 69, Your Honor. This is the RCC building, Your Honor. Now his portion of share is the ground floor, as per family settlement.
Already constructed.
No, Your Honor.
Yes, Your Lord.
No, not constructed, Your Honor. You let me complete. So, Your Honor, this is the old RCC building. He has obtained the extension for constructing. His right is confined only to ground floor. My right is confined to first floor and second floor. Now he has obtained a permission, Your Honor, for for extension of this permission for constructing over first floor and second floor also, over which he has no right. Now, if the Supreme Court allows him to construct, Your Honor, and if he constructs,
Who will allow him to construct? Nobody will allow him to
Your Honor,
construct.
if no ad interim injunction is passed, restraining him from constructing.
In 12 days, it's humanly impossible to construct first floor and second floor.
No, Your Honor. By my humble submission, Your Honor, then since he is appearing, Your Honor, a status quo as on today till 14th on the day of opening, let an
No.
Your Honor, then my only humble submission, Your Honor, since they are appearing before this one.
Let him file the objection.
Your Honor, status quo will not cause any harm when my title is admitted. My learned brother will not
See,
be.
I'll give you a short date. Just immediately after opening.
Your Honor, in the meantime, if they start constructing.
It's not possible. You are apprehending that he will construct the ground floor, first floor, third floor, everything within these 2 weeks.
No, not within 2 days. But Your Honor, if they start constructing, Your Honor, the nature and character of the suit will change because he has no right and title and interest over.
You cannot just say and
Then
you cannot establish how this nature and character of the suit will change.
If they
When you do not have any, when he doesn't have any right, He may construct anything. He may construct those towers. Remember that 2 towers in Delhi?
Yes, Your Honor. But my respectful submission, Your Honor.
Name also those 2 towers.
that were demolished.
Others colony.
Others colony, yeah.
But my humble submission, Your Honor, those were illegal constructions. Here the
Here
only
you are saying it is legal.
no, what I am submitting it is illegal construction. But Your Honor, the problem arises, the dispute is between siblings. And now they are claiming this plot of land which is my share, Your Honor. And trial court has come to it.
Really very weird. Siblings are very weird. One
So-
is constructing and one is not allowing. See?
But Your Honor, as per my learned brother will not be able to dispute my title over Schedule A property. He has admitted my title over Schedule A property, over which this G+3 RCC building is standing. He has admitted it.
So yes.
My lord, only
Are you sure on 16 July he'll be able to construct with this rain?
Your Honor, my apprehension is that they will construct. My apprehension is there. My
See,
learned
with this rain in tow,
My-
are you sure they'll be able?
my lord, just one submission.
What kind of machine would be?
Only one submission, my lord. Only one submission. My apprehension is that they will start construction over this property. If my learned brother gives an undertaking that they will not construct. If he does not want to give undertaking, that means they will start construction, taking advantage of the vacation
He
period.
has no right title.
No, he cannot deny. He is admitted in the written statement.
I know people do take advantage in the vacation period, but
So, Your Honor, when he is admitted my title,
maximum, at the most he will construct only 1 floor, maximum in 16 till 16th.
my lord, then that will change the nature and character, my lord.
Won't.
So, Your Honor, then I will just place the judgment of one division bench. The whole object of granting injunction is to protect the subject matter. Your Honor, if the subject matter in dispute is not protected, Your Honor, then the instant appeal and injunction application will become infructuous, my lord.
I'd like to hear. I'd like an in-depth elaborate.
Yes, my lord. So
in-depth elaborate hearing, which we do not have time today.
my lord, I agree. So, my lord, I will not place the judgment then. But my only submission is that since the matter requires a deliberation,
Maybe on 14th. On 14th. Today is 31st. On 14th. On 14th.
my lord, till then the status quo, because my lord, nothing will happen. If status quo is directed to be maintained 14 days, he will not suffer anything.
Before that, I'll file the objection. On
Fine.
14, it can be decided.
He can.
On 14,
Yes,
it can be
till
decided.
then.
I'll file the objection.
My lord,
Yes.
till, yes, no, fine.
That much he is agreeing.
So that means only 14 days left.
I'll put it on record on objection, and then after that on 14th.
My lord, if he gives he says that on
interim stay will be taken into consideration.
my lord, till then no construction, my lord. The nature and character, if it changes, my lord. What 14? If my lord, if 14, the matter will be heard and finally disposed of.
Yeah, status quo cannot be granted at the drop of a hat. You see.
No.
I'll have to go through an elaborate hearing.
My lord, here there is an admission in the written statement. He does not dispute my title over the property. He does not dispute.
No, he is filing an objection.
Yeah, I can show it from his own documents, Your Honor. He does not have any
No.
right.
this
He
is-
has not disputed.
So earlier matters were something different where I can grant status quo immediately. But this matter is relating to land between 2 brothers. So let's see. Let's hear
That's
you
why, my lord-
properly on 14th.
My lord,
on 14th. On 14th.
And yes, the RCC columns are already erected, my lord. They will cast the roof.
I've seen the columns on 14th.
My lord, till then they may be restrained from.
Already there was a status quo order. It was vacated. by the
Yes,
trial.
that's the problem. And status quo order which has been vacated, my lord.
That's why I'm not granting this.
Yes,
The-
My lord, if you have peruses the impugned order, that is contrary to the pleadings of the parties.
So I won't go into that depth today.
My lord,
If I go into that depth, then I will have to. These other matters will be.
yes, my lord. But I'm not asking for an injunction. What I'm submitting as on
The
today,
matters will be then left over.
my lord, I'm not asking for an ad interim injunction.
I
my
will
lord.
file my objection.
Even status quo also I'll have to.
Also, I had requested for a copy. He had not given me.
No, my lord.
Huh?
No,
I had
it's
requested
not.
For a copy, he said it is not available.
No, it's not
I don't
available.
have the copy
He
also.
just today morning he told me that he will be appearing. I said that if you would have filed the caveat, I would have served you the copies.
Then I will take up the hearing. Then other matters will be left over. Then I'm sorry.
Well, the matter is of urgency, and he is showing reluctancy not to give an undertaking.
Sorry, other matters will be left over. Really. I cannot.
My matter will become infectious, Lordship. It will not hear today.
No.
Lordship, it is an urgency, Lordship.
See, as it is, I am suffering from very high pressure today. Very high.
Lordship, in that case,
If
Lordship,
one
it will
survive-
take 5 minutes, Lordship.
Stay alive for another 1 year, please.
My matter will take only 5 minutes, Lordship.
If Lordship allows, I will do my matter. It will only take 5 minutes, Lordship. Only 5 minutes.
5 minutes will be too much.
Lordship, it will become infectious, Lordship.
Right, 14th of fix kori ase, okay.
Okay, then you can start. Other matters will be left over. Really sorry.
Lordship,
We can
let it-
start.
Let it be on 14, we'll file. the
Right, he has
objection.
not filed a caveat, so my learned brother does not have
No,
an ipso
that will
facto
not
right to
That will not preclude
object
me
to
from
the,
objecting.
yes, but he does not have an ipso facto right to object to the prayer.
You can start then. We'll take it up.
Well,
Other matters will be left over. I'm sorry.
My very serious. It will only take 5
Item
minutes.
number 20 is
Only
basically
5
very
minutes.
serious.
No,
matter.
no, no, no.
Item number 20, Miller.
Lordship may do one thing, take this matter up as the last item. Our-
Yes, yes.
No, no,
Yes.
no.
Lordship,
Miller,
only
my
5 minutes.
my item is
my lord, it's
on-
my lord, considering the interest at the bar, what my humble submission, my learned brother, if he gives assurance, he will not construct. I'm not seeking for an addendum order.
You won't give any assurance.
So that means he will construct. He will go for
My
construction.
only instruction is to oppose for the status. How can I give?
You can start. You can start. We'll take it up. Other matters will be left over. Really
No,
sorry.
my lord, my lord, item number 20, my lord. My lord, 1 minute, my lord. My item number 20, my lord.
You see all these.
My case is fixed for 5/7/2020 for
No, no.
judgment, my lord. Without hearing me, my lord.
No, no, I cannot take
But
up.
that's why, my lord, I have.
Then you till this is over.
So,
You wait till this is over.
Lordship, item number 19,
Others-
Lordship, it's very urgency.
Till this is over.
My matter also became infectious, Lordship. It will not take up.
No, no, then please kindly wait till this is over. That's why I'm asking them to wait.
He's a cat hurting me.
That's why I'm asking them to wait. Let him start. They're not allowing him to start. You wait till 8 o'clock, 9 o'clock, whatever time. You wait. Let him start. Okay.
But in only thing, in item 20, my lord, the service is not complete. Even though your lordship take the hearing, my lord, the POXO matter. Service is not complete. And secondly, my-
Item 20.
yes, madam. And they have not taken steps. also.
Steps already taken. Already taken.
No.
Steps taken. Steps. Kindly see. Kindly see. Kindly see steps taken.
Lordship, kindly table
So na,
for
8 steps taken. It didn't lose on the day.
my lord,
But it has not.
Yes, yes, you can start. it.
considering the difficulties, and my lord is also not feeling well, let it be taken up on 14th. If they construct, I will file an IA and I will try and press the matter on 10th. I will not press for, because since this Home Court is not feeling well,
Yes,
so I will
yes.
not press for,
Thank you so much.
because my learned brothers are also having some urgency. Let him start construction. I will file an IA again.
Yes. Our learned counsel, Mr.
AK Rayman.
A.K. Rai, for the petitioner, learned counsel, Mr.
Caesar Ahmed.
Appellant, no?
For the
Petitioner, no, appellant. Appellant, please. Appellant to applicant.
he is for the.
I am for the appellant.
And learned counsel,
I am
Mr.
for the defendant. Respondent.
Name,
My ZZ Ahmed.
GZ Ahmed for the respondent. As agreed by both the parties, list the matter on
My lord,
14th.
my lord, FAO can be admitted, because
Admitted, yes.
yes, FAO can be admitted.
FAO to admit কৰি দিয়া
In-
এইটো as agreed নিলিখিবা এইটো লিখি দিয়া admit লিখি দিয়া no appellant to serve notice to the respondent during the course of the day
By tomorrow, my lord. It's today.
within 2 days লিখি দিয়া within 2 days call for the LCR not decided no
Decided. It's
completely
over.
decided LCR লিখি দিয়া trial court record no LCR not trial court records
Only for the miscase your lordship may call, because title suit is pending.
yes only for the
the
miscase.
miscase. And
This is a FAO also miscase.
Miscase.
LCR of miscase number, trial court record of miscase number.
Miscase number.
Miscase number 982.
90.
982/24. From the Court of the Learned Civil Justice, Senior Division number 2, Kamrup Metro.
982.
Or it will liquidate as agreed by both the parties.
But there only one observation.
I'll write.
Only one observation, I humbly pray. My learned brother has submitted it. In the meantime, he will file the objection.
Yeah.
And on 14th, the matter may be taken up for consideration.
As submitted, meanwhile, liquidate. Meanwhile, I to liquidate as submitted by learned counsel for the respondent. objection to be filed on or before 14th.
Yes. And on that day, the interim prayer will be considered.
And the prayer for interim stay will be considered on that date on the date fixed.
On 14/7.
Only copy
I'll
within
have-
24 hours.
Yes, tomorrow I will give it.
Tomorrow,
Copy
within
I-
2 days, 2 days, within 2 days, yes.
Tomorrow I will give you.
Otherwise, you won't be able to file then.
Yes,
he
yes.
will-
Yeah, I will be not be able to.
Then he will be at loss.
Yes,
Okay.
On 14/7. Definitely.
much of this.
May it please, your lordship.
Yes, yes.
Lordship, in this criminal revision petition, we challenge the order dated 31/5/2025.
Hmm.
Lordship, accordingly, matter was listed on 17/6/2025. Notice was issued upon the respondent. Immediately on 19/6/2025, we have taken the steps on the same address which has been given in the complaint petition. But the notice could not be served due to insufficient address. And Lordship, the matter is fixed on 8 for final argument. Lordship, I am only pressing for for abeyance of the lower court proceeding at this stage, because otherwise the documents which we want to come on record is directly relevant to the instant matter. Lordship, for the proper adjudication of the matter, these documents are required to become on record. Lordship, if therefore, Lordship, I am only submitting that lower court proceedings may be kept in abeyance till the other side appears. And also, Lordship, can give a pass order, can allow us to take dusty service, because this address is insufficient. Lord.
অফিচ নোটটো নাই দেখোন ইয়াত তেনেকে তেওঁ যি কৈছে অফিচ নোট এটা থাকিব লাগিব
There is an order, Lordship, 17/6/2025.
এইটোত আছে নি সাপ্লিমেন্টারি ফাইলটো লাগে এড্ৰেছ Third learned counsel, Mr.
B. Kumar,
B. Kaur.
Lordship.
For the petitioner, it is submitted on behalf of the petitioner that notices have been issued to the respondent, but the notices were returned with remark addressee could not be located. Seen the report on the notice. Oitu palu. Office note also reflects the submission of the learned counsel for the appellant. It is further submitted, appellant petitioner. It is further submitted that this that the case being what?
Posted for final argument on 8th of July.
Complaint case number 1237 of 2019 is fixed for final argument as the matter is of urgent nature.
The lower court proceeding may be kept in
And
abeyance.
as the case will be disposed of after final argument fixed on
Fixed on 8/7/2025.
8/7/2025, it appears that further proceedings of the complaint case number 1237 of 2019 be stayed. Meanwhile, petitioner be stayed till the next date of listing. Meanwhile, petitioner to take steps to issue notice to the respondent
Through dusty service.
through dusty service, routed through dusty service, list the matter on 31st July. Till next date of listing, state till 31st July.
I'm deeply obliged.
To Hari, call for the scan copies of the trial court records.
Deeply obliged.
Number 20 and 21.
My lord, in this case, my lord, a case is registered, a case is filed on 31/7/2019, my lord.
No step for issuance of notice on respondent number 2 has been received. POSCO case.
Yes, my lord.
You
What
have
happened in
next
this
step.
case, my lord?
Huh? I'm not well. You brought this matter before me. Yes.
Lord, item 22, Lordship, may kindly take up IA number 2136, my lord.
Hmm.
I have filed for the stay, my lord. What happened 2136, my lord, ISC with. 2136. My lord, what happened in
In a
this?
bond